Q1 Discuss about Muslim law. Discuss its basic principles. Trace the history and development of Muslim law. Ans. Muslim law is a personal law. Muslims are governed by it, just as Hindus are governed by their customary as well as codified law. As far as Muslim law in India is concerned, Muslim law means that portion of Islamic civil law which is applied to Muslims as a personal law. The term Muslim law is also known as Mohammedan law, though there is big difference between two expressions. Eminent author Sir A. Faizi has said that strictly speaking the religion taught by Prophet was Islam and not Mohammedanism. The people who believe in it are Muslims and not Mohammedan. Therefore Mohammedan law as applied in India, as personal law for Muslims, is actually part of Islamic law. It consists of the injunctions of Quran, of traditions introduced by practice of the Prophet, of the common opinion of the jurists, ijma, of the analogical deductions of these three, qiyas, and of the pre-Islami customs not abrogated by Prophet Muhammad. It has been supplemented by the juristic preference, ijtihad, and state legislations and judicial precedents of different high courts, Privy Council and Supreme Court. Quran, the foundation of Muslim law. Muslim law is founded upon Al-Quran, which is believed by the Muslims to have existed from eternity, subsisting in the very essence of God. The Prophet Muhammad himself declared that it was revealed to him by the angel, Gabriel, in various portions and at different times. The main characteristic of Muslim law is that it has always been defined in terms of religion. The word Muslim is a noun, of action. Its meaning is that one who adopts the faith of Islam, and Islam is a word which in Arabic term means submission to the will of God. Therefore, one who believes in the principle of the unity of God, i.e. God is one, and b. Prophet Muhammad is messenger of God, is Muslim. There are three important elements of this religion. They are Islam, i.e. submission to the will of God, d. Tawhid, dogma of the unity of God, and c. Akhwadi, brotherhood. One who subscribes to these basic elements of Islam is known as Muslim. It is believed by Muslims that their religion has a divine origin and it is in existence since the beginning of the world and will exist till doomsday. The only thing is that wherever religion is corrupted and people forget the real sense of it, God in His infinite mercy sends a Rasul, messenger or reformer, in the world. Such Rasuls time to time tried to do away with the malpractices prevailing in those days. He warned the people against those evils. What is Islam? In the religious sense, Islam means submission to the will of God, and in secular sense Islam means the establishment of peace. History of Islam. The history of the development of Muslim law has been divided by various Muslim scholars in their own ways. Sir A. Faizi divided the history of development of Muslim law into 5 periods. On the basis of their study we can divide the history of development of Muslim law into following 5 periods. A. From R1 to AH.10, period covering last 10 years of life of Prophet. B. From AH.10 to AH.40, the period of first four caliphates. C. From AH40 to AH30, most important period of development of Muslim law. D. From AH300 to 1924 AD, period in which the caliphate was abolished. British rule was established. A. From 1924 onwards. A. The period of AH1 to AH10, the first period. This period was the last 10 years of the Prophet Muhammad's life. In that period all verses of the Quran were collected and composed. Important ahadith also came into existence in those days. Quran was the direct revelation of the angel Gabriel to Prophet Muhammad. Prophet conquered Mecca and Medina. During the last few years of his life he took up the task of legislation. Most of the verses of Quran were revealed during that period. There are many important judicial decisions and traditions which pertain to that period. As per Islamic law, the inspiration from Almighty comes through either by direct manifestation, zahir, or it may be implied, batan. The words of Quran, as per Islamic faith, were the very words of God. The actions and sayings of the Prophet were directly inspired by the divine power, out of which the traditions are supposed to be indirect revelation. The verses of Quran were the very words of God. B. The period from AH10 to AH40, the period of those 30 years was of the first four caliphates or successors of Prophet. There were two main contributions of this period, i.e., I. the collection and editing of the text of Quran, and e. close adherence to ancient practice under the fiction of adherence to Sunnah. I. The texts of the Quran, during the life of Prophet has been preserved by his companions either in memory or by inscribing them on the bones, date leaves and tables of stone. After the mass slaughter of the large number of reciters in an expedition against the importers Mu'alima, Z. a close companion of Prophet Muhammad was employed by Caliph Abu Bakr, his reign to collect and codify the verses of Quran. He accomplished between AH11 to 14. Such collection of verses of Quran were again got revised from Z by 3rd Caliph Uthman. Then an authenticated and uniform text was made which is used throughout the Muslim world even today. E. The sayings and decisions of Prophet were not collected under the authority of state, but their collection was left to the person who were most learned in tradition. They gathered round themselves and stored up all the sayings of Prophet. Such zeal gave rise to many a false and inaccurate tradition. The leanings and aptitude in deducing the rules of secular common law of same comparisons of Prophet i.e. Ali, Umar ibn Umar, Ibn Masud and Ibn Abbas got prominence. They became the basis of many principles of Mohammedan jurisprudence. The second characteristic of the second period was that administration of justice was established during the period of first four caliphs. After the death of Prophet, Abu Bakr himself administered justice as the Prophet had done before him. He delegated his judicial functions to Umar, who was appointed the first Qazi, Qadi. During his days the powers and jurisdiction of the Qadi, Qazi, was properly defined. After Umar, Ali was a noted jurist. He was assassinated in AH 40. This brought to close an age of the rightly guided caliph. That period was characterized by a close adherence to the ordinances of Islam. The law was then administered either by the head of the state or the church. It was during the later days of Umayyad's dynasty when a study of law was largely influenced by recently introduced science of divinity and scholastic logic. In that series, efforts were made to classify the laws under different subjects to introduce the use of technical phraseology and the arrangement of different sources of law. After the fall of Umayyad's destiny, Abbasides came into accession. In AH 132, the Abbasides caliphs patronized learning and extended their help and encouragement for study of law and jurisprudence. It was due to their efforts that Baghdad became the center of culture, and the jurists and traditionists of those days were attracted to reach there. c. The third period from AH 40 to AH 300. The third period of the development of Islamic law was from AH 40 to the 3rd century. That period was remarkable in the sense that the collection of traditions was done during those days by famous traditionist Bukhari and Muslim. Moreover, during the early part of that period 4 schools of Sunnite law, like Hanafi, Shafi, Maliki and Hanbali came into existence, and they did a lot for the development of the Muslim law. Hanafi school. The first school Sunnite law is Hanafi school. This school was established by Imam Abu Hanifa, 8699 to 15766. The main characteristic of this school of thought was that it made its reliance mainly on the principle of qita, or analogical deductions. Abu Hanifa, due to his talent and thorough study, possessed remarkable powers of reasoning and deduction as well as retentive memory and clear understanding. The result was that people flocked to his lecturers and a large number of people became his disciples. Abu Hanifa acquired the title of the unholder of the private judgments. He recognized only 18 traditions out of the great mass which in vogue. Abu Bakr was known as the founder of the Mohammedan science of law. He gave prominence to the doctrine of qiyas or analogical deduction. He recognized the authority of local customs and usage as guiding the application law. The most remarkable work done by Abu Hanifa and his disciples was that the efforts were made for the codification of laws. Most of the Muslims of the world, especially of India, Afghanistan and Turkey, are the followers of Sunni Hanafi school. Maliki school. This school of thought was established by Malik ibn Anas, 97 713 to 179 795. Malik relied much more on the practice of Medina rather than qiyas of the Hanafi school. The only and main book of Malik was Muwatta, which was actually the oldest corpus of Sunnite law. He was not only the traditionist but a jurist, but he leaned more upon traditions and usage of the Prophet. He recognized the principle of public welfare, muslahat, as a basis of deduction. He recognized one more source of law, i.e. istidlal, besides 4 other sources viz. Quran, Hadith, Ijma and Qiyas. His collection of traditions, namely Al-Muwatta, contains about 300 traditions. The followers of Maliki school of thought are mainly found in northern Arabia. Shafi's school. This school of thought was established by Imam Shafi. He was one of the greatest jurists of Islam. He did not only create classical theory of Islamic jurisprudence but also perfected the doctrine of Ijma. His contribution was known as Ash-Shafi. Imam Shafi was noted for his balance of judgment and moderation of the views. He allowed greater scope of Ijma, consensus of opinion. Hanbal school. Imam Ahmad bin Hanbal was founder of this school. He was man of very saintly character. His reputation stood very high as traditionist and theologian. His remarkable work on tradition was known as Musnadul Imam Hanbal. It contained about 50,000 traditions. Shia schools and sub-schools. The schools of Shias was founded by Imam Ali, who was the son-in-law of Prophet. He was recognized by Shiites as successor of Prophet in temporal and religious matters. The followers of Shia school refused to recognize the principle of election of Imam by the people. They said that Hazrat Ali was sometimes appointed as successor by the Prophet as his vicegerent at some occasion. The number of Shiites, as estimated by Sir A. Faizi, are about 30 million. The period from 300 AH to 1924 AD, the first period of the development of Muslim law, was long as well as varied. This period concluded at the time of abolition of Caliphate, i.e. 1924 AD by Turkish Republic. After that period there was no recognized head in Sunnite schools. The scholars then devoted themselves only to the methods already laid down by founders of those 4 Sunni schools. No one thereafter was recognized as having the same rank as the founder himself. The doctrine of a. Taqlid, following or imitation, and b. Ijtihad, the power of independent interpretation of law, which became popular in those days. The later jurists and lawyers were not at liberty to cross the barrier made by the former jurists' founders. The power to take independent judgment in the matters of religion was not permissible. As such, this period was known in the name of the closure of the gate of interpretation. The period from 1924 AD to present day, the fifth and last period of the development of Muslim law, commenced with the abolition of the Caliph, Sultan. In this period, the most remarkable achievement was that secular laws, Qanun, were made in the domain of sacred law, Shariat, in the various Muslim countries. Shariat then became only moral code for people and it lost its juristic sanction. So far as the last phase of Muhammad supremacy in India is concerned, it came to an end with the establishment of British rule. During Mughal period, Sunni Hanafi law was prevalent as the law of land. When Britishers took the whole administration of India in their hands, the influence of English common law and the principles of equity were much more apparent. The Mohammedan law was then applied as a branch of personal law to all those persons who belonged to Muslim religion. The British government gave due regards to the personal law prevalent in India. Both Hindus and Muslim law officers were appointed for the administration of justice for civil and criminal cases. All cases pertaining to Hindus were decided by the courts with the help and opinions of Hindu law officers, i.e. Pandits, and of the Muslims by Muslims law officers, i.e. Maulvis, according to their respective personal laws. Thereafter, Regulation 2 of 1772 envisaged that in all suits regarding inheritance, succession, marriage and caste and other usage or institution, the law of Quran will be applied to the Mohammedans. In 1862, Indian Penal Code and Criminal Procedure Code came into force. These codes made the Muslim criminal law disappear from India. The Islamic law of evidence also remained in force till passing of Evidence Act 1872. To point out the reasons that led to the formation to the Sunni and Shia schools of Mohammedan law. Bring out clearly the main points of difference between the two schools. There are two main schools of Muslim law, the Sunni and Shia. The majority of Muslim are Sunnis, and hence it is presumed that the parties to a suit are Sunnis unless otherwise is proved. As Tayyibji says, where it is not alleged, nor shown that the parties are Shias, there is a presumption that they are Sunnis, to which sect the great majority of Mohammedans of this country belong. The death of Prophet raised a momentous question. One party advocated the principles of succession while another pressed for the election of the successor. The Shias advocated that the pious office should go by the right of succession, and thus imama, headship, should be confined to the Prophet's own family or his nominees, while the Sunnis were of the opinion that the office should devolve by election and it should be chosen by votes. The Shias repudiate the authority of Jamaat while the Sunnis advocate it. Thus the difference between the two was based on political events and not in law by jurisprudence. Shia school. Sunni school. 1. Marriage. Muta or temporary marriages are lawful. Muta marriages are not lawful. Only the father and grandfather are recognized as legal guardians for marriages. Marriages contracted by others have no legal effect. Besides father and father's father, howsoever, brothers, other paternal relations, mother and maternal uncle, etc., are also recognized as legal guardians for marriage. Presence of two witnesses is essential at the time of dissolution of marriage, while at marriage, they are not essential. Two witnesses are not necessary at the time of dissolution of marriage, but are necessary at the time of marriage. Marriage cannot be cancelled on the ground of inequality between the two parties. Marriage can be cancelled on the ground of inequality between the two parties. They do not recognize the doctrine of valid retirement, i.e. the presumption of the consummation of marriage if the husband and wife retire into the nuptial chamber and there is no impediment to sexual intercourse. The doctrine of valid retirement is recognized. Remarriage after the third triple repudiation is never legalized. Such remarriages are legalized. 10 months is the longest period of gestation. The period of gestation is 2 years. V. Marriages are either valid or void. V. Marriages may be irregular also besides being valid or void. 2. Dower. I. The minimum amount for dower is not fixed. I. 10 dirhams is the minimum amount of dower. E. Presumption of 500 dirhams is the maximum in case there is no stipulation. E. No upper limit. E. Presumption of prompt dower in absence of any stipulation. E. The part is prompt and the part is deferred. Talaq. 1. Talaq must be pronounced orally in the words of Arabic language to be used. 1. Talaq can be given orally or in writing. 2. Witnesses are required while doing so. 2. Witnesses are not required. 3. Talaq pronounced in state of intoxication or by force is void. 3. Talaq given in state of intoxication or under pressure is not held void. 4. Talaq ul sunnat is recognized as best form of talaq. 4. Talaq I biddat and talaq ul sunnat both are recognized. Guardianship. The mother of a daughter up to the age of 7 years and of son up to 2 years is legally entitled as guardian. Mother of a daughter up to age of 7 years and of a son up to age of attaining puberty is entitled to guardianship. Maternity. If a child is born as a result of illicit relation of mother, the child is treated as motherless. Maternity of a child is recognized from such mother who gave birth to child without having any consideration of the reasons of birth. Waqf. Without delivery of possession of property the waqf is invalid. Mere declaration is enough for valid waqf. Preemption. Right of preemption is recognized only in case of co-sharer who are 2 in number. Besides co-sharer, a participator in the appendages or neighbor owner of property can claim right of preemption. 10. Wills. A person is an absolute owner of the 1/3 of his estate and can bequeath that 1/3 without the consent of the other heirs. Consent of the heirs essential. In case of the legatee's death in the lifetime of the testator, the legacy passes to his heirs unless it is revoked by the testator. It lapses. 11. Inheritance. There are only 2 classes of heirs, namely sharers and residuaries. 3 classes: A. Sharers, B. Residuaries, C. Distant kindred. According to the law of primogeniture, the eldest son gets the deceased father's garment, the signet ring, the sword and the Quran. The doctrine of primogeniture is not recognized. A Shia childless widow is not permitted to take any share in her husband's immovable property. There is no such distinction between real and personal property, and the childless widow can inherit even the immovable property. Only the husband and not the wife is entitled to return. Both husband and wife can take by return. A man is excluded from inheritance if he has intentionally caused the murder of the person whom he is going to inherit. He is excluded from inheritance, no matter the murder was intentional or unintentional. 3. What are the main sources of Muslim law? Following are principal sources of Muslims law. Primary sources of Muslim law: 1. Quran. 2. Sunnah. 3. Ijma. 4. Qiyas. Secondary or formal sources of Muslim law. 5. Customs, URF. 6. Judicial precedents. 7. Legislation. 8. Good conscience and equity. 1. The Quran. The primary source of Muslim law is revelation, which has been of two kinds, express and implied. The Quran is composed of such express revelations as were made in the very words of God to Muhammad when he was bestowed with the office of the Prophet and Messenger of God. It is divided into 114 chapters and is composed of about 6,237 ayats. It is in the form of series of communications addressed by God to the Prophet. The communications were declared to the people on a large number of different occasions in the last 23 years of the life of the Prophet. It deals with variety of subjects and very small part of it comes into the domain of law. The law-making verses are about 200 in number and are scattered in different parts of the Holy Book. 2. The Sunnahs. With the death of Muhammad, the living source of inspiration terminated and a reference of him being no longer possible. The problems had to be decided by supplementing from his sayings. The term "Sunnah" is applied to the traditions or precedents not merely emanating from Prophet but also from his companion. Sunnah literally means a path, a procedure, a way of action. They are of three kinds. 1. Sunnat ul-Fil, i.e., traditions about what the Prophet did himself. 2. Sunnat ul-Qawl, i.e., traditions about what he enjoined by words. 3. Sunnat ul-Takir, i.e., that was done in his presence without his disapproval. Hadith or Hadith are one of the form of Sunnatul Takrir. These abadis form the foundation of the law during the period of the first caliphs who were the companions and relations of the Prophet. This is the second source of the Mohammedan law. 3. The Ijma Ijma means the opinion of the companions of the Prophet Muhammad. Under this collective name are included the explanation, elucidations and the decisions of the disciples of the Prophet. Sir Abdur Rahim has defined it as the agreement of the jurists among the followers of Muhammad in a particular age on a particular question. After the death of Prophet and as the expansion of Islamic influence took place, a large number of fresh facts and new problems cropped up which could not be decided by reference only to Quran and a Hadith. The jurists then took the recourse through the principle of ijma, that is the consensus of opinion of jurists on any question. The ijma is of three kinds. 1. Ijma of the companions of Prophet. 2. Ijma of jurists. 3. Ijma of people. Ijma is the third source of Mohammedan law. 4. Qiyas. Qiyas means measuring accord or equality. In Muslim jurisprudence it means common sense. According to Jung, it is a process of deduction applying the law next of the text, and nevertheless covered by the reason of the text. This source of no value to persons belonging to the school of Ahmad ibn Hanbal, the great traditionist. The Shias also do not accept qiyas because they are of the opinion that if law needs to be enlarged it must be by the imams and none else. Secondary of formal sources of Muslim law. 5. Customs, urf. A. Meaning. A custom is tradition passing on from one generation to another, that originally governed human conduct and has obtained the force of law in a particular locality. It is a natural source of law. The Muslim jurists do not expressly describe it as a source of law, but those customs and usages which were not modified or abrogated by the Prophet, remained good and valid. The primeval customs were regulated by Muhammad. The custom was not an independent source of Muslim law. During the British regime, courts in India recognized the legal force of customs on some occasions in spite of the fact that they were opposed to the clear texts of a primary text of Muslim law. This caused great dissatisfaction among the orthodox Muslims and led to the passage of Shariat Act, 1937, which abolishes most of the customs from the Muslims' personal law. Section 2 of this act lays down that if the parties are Muslims, only Muslim personal law will be applied to them in the following matters: I. Inheritance. E. Special property of females. E. Marriage. IV. Dower. V. Divorce. V. Maintenance. V. Guardianship. V. Gift. X. Waqf and X. Trust. In respect of these matters, customs or usages have no place. But customs are still applicable in matters of agricultural lands, charities and religious and charitable endowments. 6. Judicial precedents. Interpretation of Mohammedan law by the judges of the Indian High Courts and Supreme Court continue in modern times to supplement and modify the Islamic law. As such, they are continuing sources of Mohammedan law. These include the decisions of the Privy Council, the Supreme Court, as well as of the High Courts of India. These decisions are regarded as precedents for future cases. 7. Legislation. There have been many legislative enactments which have considerably amplified, altered or modified the original Muslim law. Examples: I. The Guardians and Wards Act, 1890. E. The Musalman Waqf Validating Act, 1913. E. The Musalman Waqf Act, 1923. IV. Child Marriage Restraint Act, 1929. V. Shariat Act, 1937. V. The Dissolution of Muslim Marriages Act, 1939. V. The Muslim Women, Protection of Rights on Divorce, Act, 1986. 8. Good conscience and equity. Sometimes analogical deductions fails to satisfy the jurists owing to the narrowness and inadaptability of the habits or due to hardship to the public. In such a case, according to the Hanafis, a jurist could use good conscience. Q. 4. Shariat Act of 1937. Describe some of its main features. Ans. Shariat Act 1937. Shariat Act was one of the important enactments passed in 1937 to deal with the application of Mohammedan law in India. It came in force with effect from the 7th of October 1937 in the whole territory of India except in Northwest Frontier Province. As per Sir A. Faizi, Shariat Act aims at restoring the law of Islam to all communities residing in India and doing away with customs, contrary to the Shariat, personal laws of Muslim. Main features: 1. Shariat Act, Act No. 26, of 1937 contains only 6 sections. The main characteristics of this act is that it is applicable on all Muslims without having any consideration on the schools to which they belong. 2. The another important feature is that the word "Muslim" has not been defined anywhere in this act, and that too for the limited purposes. 3. Shariat Act deals with all kinds of properties except the following: a. Charities which are other than waqf. b. Agricultural land. c. Testamentary succession in certain communities. The text of the Shariat Act 1937. This act was known as Muslim Personal Law, Shariat Act, of 1937. It was enforced on all the Muslims residing in India. Section 2. Section 2 of this Act deals with all questions, see questions relating to agricultural land, regarding intestate succession, special property of females, including personal property inherited obtained under contract or gift, or any other provision of personal law on the dissolution of marriage, including talaq, ila, zihar, khula and mubarat, maintenance, dawah, guardianship, gift, trust and trust property, waqf, other than charitable institutions and religious endowments. The rule of decision on all such issues shall be based on Muslim personal law, Shariat, when both the parties are Muslim. Section 3. This section aims at compelling the Muslim communities to give up right contrary to the Mohammedan law and to be governed exclusively by the law of the Shariat. According to this section, a person belonging to Muslim community can declare on the prescribed form according to prescribed procedure that he wishes to obtain the benefit of provisions of this Act. In case of refusal of such declaration by the competent authority, an approval could be made. Section 4. Section 4 empowers state government to make rules to carry into effect the purposes of this Act. Section 5. Section 5 states that the district judge may on petition made by a Muslim married woman dissolve a marriage on any ground recognized by Muslim personal law, Shariat. A provision regarding dissolution of marriage by courts in certain circumstances was made in this section, but it was repealed by Act 7 of 1939, i.e. the Dissolution of Muslim Marriage Act, 1939. Section 6. Section 6. Some acts and regulations already in force at the time when Shariat Act came into existence were repealed because they were inconsistent with the present Act. Q. 5. What are the essential conditions for conversion of India? Ans. Muslim law applies to I. Mohammedans by birth and e. Mohammedans by conversion. So all Mohammedans are governed by the Mohammedan law, even if they are converts to Islam. Conversion to Islam makes the Islamic law applicable. Previous religious and personal law is substituted by Islam. Conversion to another religion basically requires change of faith. To say the least, it is a matter of conviction. According to Mullah's principle of Mohammedan law, any person who professes Mohammedan religion, that is, he acknowledges that there is but one God and that Muhammad is his prophet, is Mohammedan. Such a person may be Mohammedan by conversion or by birth. According to Taibji's principles of Mohammedan law, a non-Muslim who has attained majority and is of sound mind may embrace Islam in either of two modes. A. He may simply declare that he believes in the oneness of God and the prophetic character of Muhammad, or b. He may go to a mosque, to a person who is well versed in Islamic theology, alim, where he utters kalma, la ilaha illallah, Muhammad Rasulullah, before Imam. Whereupon he is given a Muslim name by the Imam. A convert must formally profess to be a Mohammedan. It is, however, necessary that the conversion must be bona fide. The court will not permit anyone to commit a fraud upon the law by pretending to be a convert to Islam in order to elude the personal law by which he is bound. Q. 6. What is the effect of conversion to Islam on the legal status of man and woman? Ans. Conversion is renunciation of one's religion and adoption of another religion. On conversion to Islam, the status of the converts comes under Mohammedan law. The effect of conversion is prospective and not retrospective. A bona fide conversion to and from Islam substitutes the new religion of the party for his or her previous religion. We shall consider the effect under the following heads. 1. Effect on marital rights. A. Conversion of husband. If the conversion to Islamic religion is bona fide, it may bring the convert under the rules of Mohammedan law. Thus, where a married Christian domiciled in India embraces Islam and marries with another woman according to the Muslim rules, it has been held that Muslim law applies to his case and the second marriage becomes valid, and previous marriage of the husband with the Christian lady is not dissolved. Because Mohammedan law permits marriage between a Muslim male and a Kitabiya woman, a follower of one of the scriptural faiths. But if the conversion is not bona fide and it is merely pretended in order to take advantage of the personal law so adopted, the court will not allow the validity of such conversion. Thus, a Christian who had a Christian wife living, cohabited with a native Christian woman, in order to legalize his relation with the latter. He and the woman both embraced Islam and went through the ceremony of marriage. The marriage was held to be invalid, as the man had tried to escape the consequences of bigamy by embracing Islam, which recognizes plurality of wives. Skinner vs. Odd, 1871, 14 Moore IA 309. See also Sarla Mudgal vs. Union of India 1995, 3 SCC 653, where a Hindu converted to Islam. B. Conversion of wife. A non-Muslim wife cannot merely by conversion to Islam legally marry a Mohammedan during the lifetime of her non-Muslim husband and her marriage with the non-Muslim male, which was solemnized before. Conversion is not dissolved merely by the fact of her conversion to Islam. C. Effect of conversion on previous marriage. If one of the spouses becomes convert to Islam, the conversion will not dissolve the marriage validly contracted. Thus, if a husband becomes converted to Islam, his marriage with his non-Muslim wife is not dissolved. Similarly, if a non-Muslim wife embraces Islam, the marriage would not be automatically dissolved. 2. Effect on right of inheritance. When a person is converted to Islam, the succession to his estate will be governed by Mohammedan law. Thus, if a married Hindu embraces Islam, his Hindu widow or Hindu children will have no right to succeed to him, as the non-Muslim may not succeed to a Muslim according to Mohammedan law. Chedambrian vs Mane. Me 1928, 6 rank 243. A convert to Islam is not governed by his original religion, but is presumed to have accepted the tenets of the Prophet as well as Muslim personal law. According to the Shariat Act, 1937, which has abrogated customs and usages of the Muslim law, a convert cannot set up any custom relating to intestate succession. Q. 7a. What is the effect of conversion on marital rights of a Mohammedan? Explain with special reference to Dissolution of Muslim Marriage Act 1939. B. A Hindu woman is converted to Mohammedanism and leaves her Hindu husband. She marries a Mohammadan according to Muslim rites. Has she committed any offence? Discuss. Ans. Under the pure Muslim law and before enactment of Dissolution of Muslim Marriage Act 1939. A Mohammedan after renouncing Islam, loses all his or her marital right and apostasy from Islam of either party to a marriage operated as complete and immediate dissolution of marriage. In Rabian Bibi vs Ghulam Ali, Hair 1941 Lahore 292, it was held that Section 4 of Dissolution of Muslim Marriage Act 1939 is not retrospective and applies only to renunciation or conversion which might take place after the Act came in force, consequently apostasy of either party to a Muslim marriage prior to coming in operation of Act ipso facto dissolves the marriage. Section 4 of Dissolution of Muslim Marriage Act 1939 provide that marriage of a Muslim husband with Muslim wife is dissolved ipso facto on renunciation by the husband of the Islamic religion. However, where Muslim married couple renounce Islam and embrace another religion, their marriage remains intact and is not dissolved. Renunciation of Islam by married Muslim woman on her conversion to faith on any other religion does not by itself dissolve her marriage. But where woman converted to Islam from some other faith re-embraces her former faith, her marriage with Muslim husband stands dissolved. B. The conversion of a Hindu wife to Islam does not ipso facto dissolve her marriage with her husband. She cannot enter into valid contract of marriage with any other person during the lifetime of her husband, and if she goes through a ceremony of marriage after conversion to Islam she will be guilty. U.S. 494 of Indian Penal Code. In Ahmad Bucks vs. SMT. Nathu, Air 1969 All. 75, it was held that marriage between a Hindu couple does not dissolve automatically after a fixed period on the conversion of Hindu wife to Islam. In the case of Ram Kumari 1891, 18.264, a Hindu married woman embraced Islam in the belief that her conversion to Islam would ipso facto dissolve her marriage with her Hindu husband. After conversion she married again with a Muslim. She was prosecuted for bigamy and convicted. Q. 8. A Hindu having a wife and 2 sons, converted to Mohammedanism and married a Muslim lady and had 2 sons from her. State who shall inherit his property on his death and in what shares. Ans. Where a person converts his religion to Islam, then by necessary implication he will not be Muslim by religion only, but he will be subject to Muslim personal law with regard to succession or inheritance also. In Controller of Estate Duty Mysore vs Haji Ahmed Sattar and others, Air 1972 South Carolina 2229, Supreme Court held that it is the rule of Mohammedan law, the correctness of which is not capable of any doubt, that it applies not only to persons who are Muslim by birth but by religion also. Accordingly, a person converting to Mohammedanism changes not only religion but also his personal law. Therefore, the effect of conversion to Islam is to bring about a complete change as regards the rights of inheritance. Succession to the estate of a convert to Mohammedanism is governed by Mohammedan law. In Vohra Bhai Khatija Isahai vs Vohra Karim Bhai, Air 1974 Guj 4, it was held that in case of a Hindu convert to Islam, succession and inheritance are governed by Mohammedan law and not by Hindu law. Similarly, reference may be made to Chandra Shekharappa vs Government of Mysore, Air 1953 Ms. 621, wherein it was held that where a Hindu who had a Hindu wife and children embraced Islam and married a Muslim woman and had children by her, his property would pass on his death to his Muslim wife and children and not to his Hindu wife or children, because under Muslim law, a Hindu cannot succeed to the estate of a Muslim. Therefore, in this case, property of person who was earlier Hindu and was having Hindu wife and children but converted to Mohammedanism and got married with Muslim woman and had 2 sons from such Muslim wife, will pass, on his death, to his Muslim wife and children. His Hindu wife and children will get nothing. Q. 9a Mohammedan becomes convert to Christianity. The wife then marries another man before the expiration of the period of iddat. State if she is guilty of bigamy under Section 494 IPC. Uns. Before the Dissolution of Muslim Marriages Act, 1939, apostasy from Islam of either party to a marriage operated as a complete and immediate dissolution of the marriage. Under Section 4 of the Dissolution of Muslim Marriages Act, 1939, however, mere renunciation of Islam by a married woman or her conversion to any other religion cannot by itself operate to dissolve her marriage, but she may sue for dissolution on any of the grounds mentioned in Section 2 of the Act. Section 4 only applies to the case of apostasy from Islam of a married Muslim woman, and apostasy of the Muslim husband would still operate as a complete and immediate dissolution of the marriage. In the case in hand, apostasy from Islam of the husband operates as an immediate dissolution of marriage, and the wife is free to remarry without observing iddat. Therefore, she is not guilty of bigamy under Section 494 IPC. Q. 10. What is effect of conversion to Islam with colorable, fraudulent or dishonest intention? Give your reply with the help of some decided cases. Uns. The effect of conversion to Islam with dishonest, fraudulent or colorable intention. One of the essential conditions for a non-Muslim for conversion to Islam is that there must be good and bona fide intention behind such conversion. If it is found that the object of conversion was not bona fide, a converter can be punished in law. For example, in the case of Skinner is example 1871-14, Mir 309, one Christian woman was cohabiting with a married Christian man. In order to legalize their living as wife-husband, both of them converted to Islam and then remarried. Later on, when the question of validity of their marriage arose in the court, Privy Council in that case held that the such marriage was "null and void", on the ground that the conversion of the parties to Islam was a fraud upon the law and it was not bona fide. In one other case, Rekhe Bibi vs Anil Kumar, 19482 Cal. 119, it was held by Calcutta High Court that where the party puts forward his or her conversion to a new faith is creating a right in his favor to the prejudice of another, it is proper and necessary for a court of law to inquire and find out whether the conversion was a bona fide one. In the instant case, since the conversion of the plaintiff, woman, was with a view to get rid from the unhappiness caused in her mind due to her husband's impotency, her conversion to Islam was not bona fide. In the case of Ram Kumari 1891-18 Kal. 254, a Hindu woman assumed that if she adopts Islam, her marriage, took place earlier according to Hindu law, will automatically be dissolved, and as such she adopted Islam. Her conversion to Islam was therefore held non-bona fide by the court and she was prosecuted and convicted for bigamy. In view of the decision of the above cases, a question arises: what is the true test of conversion? The actual position in this regard is that any religion depends upon belief. It is inner thought or feeling of a man, but a partial difficulty in this regard is that the internal thoughts of a person can neither be measured nor be tried in the court. Due to this reason, only no "hard and fast" rule can be laid down even for the external tests too. Only circumcision is one of the tests, but it is also not a final and conclusive test or gauge the sincerity of religious belief. The court, however, can find out the true intention of person lying behind his acts. So far the genuineness or bona fideness of the conversion of the Islam is concerned, it can be found out by the court from the circumstances of the case whether a pretended conversion was really a means to some further ends. If conversion is not inspired by religious feelings and it is done for the sake of achieving one's own motive or purpose, it will not be recognized as bona fide. Summarily, it can be said that the conversion to Islam is valid and bona fide if converter professes Islam and that it is not pretended or colorable one for the purpose of perpetrating a fraud upon the law, and b. the whole of the converter's conduct and the evidence of surrounding factor is such as to run counter to the presumption of his or her conversion to Islam. Q. 11 Marriage among Mohammedans is not sacrament but purely a civil contract. Discuss the statement with reference to contractual nature of Muslim marriage. Ans. Marriage among Hindus is a sacrament tie between man and woman. It is considered to be holy union of husband and wife for the performance of religious, social and spiritual duties. However, marriage under Muslim law is not a sacrament but is a civil contract. Marriage or nikah under Mohammedan law may be defined as legal process by which sexual intercourse and procreation and legitimation of children between man and woman is perfectly lawful and valid. According to Dr. Jung, marriage, though essentially a contract, is also a devotional act. Its object are rights of enjoyments and procreation of children and regulation of social life in the interest of society. Juristically speaking, marriage among Mohammedans, being civil contract, require following essentials. Firstly, marriage, like any other contract constituted by offer and acceptance, ijab uqbul, to other party, and marriage becomes complete only when other party has accepted that offer, qabul. Such offer and acceptance must be in one meeting in the presence of witnesses. It is also necessary that parties contracting marriage must be acting under their free will and consent. Secondly, parties to marriage must have capacity of entering into contract. In other words, they must be competent to marry. Every Muslim who is of sound mind and who has attained puberty may enter into contract of marriage. Parties must be able to understand the nature of their act. Marriage of a minor may be solemnized provided with the consent of guardian. Thirdly, there should be no legal disability to enter into contract of marriage. Legal disability means the existence of certain circumstances under which marriage is not permitted. These disabilities have been classified into following three heads. A. Absolute incapacity, which arises from I. Consanguinity, E. Affinity, and E. Fosterage. B. Relative incapacity, which arises from cases which render the marriage invalid so long as the cause which creates the bar exists, and the moment it is removed the incapacity ends and marriage becomes valid. Unlawful conjunction, fact of marrying, fifth marriage, absence of proper witness, difference of religion, and marrying with woman undergoing iddat are all cases of relative incapacity. C. Prohibitory incapacity arises when Muslim woman has more than one husband and when Muslim woman marries non-Muslim. Fourthly, meher or dower is settled by husband upon his wife in consideration of the marriage. He may settle any amount he likes, but the same cannot be less than 10 dirhams. Wife is entitled to claim prompt dower on demand at the time of marriage. However, deferred dower is payable on dissolution of marriage by divorce or death. Fifthly, under Mohammedan law, marriage is not permanent tie, and any Muslim of sound mind who has attained puberty may divorce his wife whenever he desires without assigning any reason or cause. Thus it becomes clear that marriage among Mohammedans is purely a civil contract. Q. 12. What marriages are void and invalid, and what marriages are mere irregular under Muslim law? Briefly discuss the legal consequences of such marriages. Ans. Void marriage in Muslim law. Due to the following reasons the marriage, nikah, are deemed void. A. Consanguinity, batil, in Muslim law. If a person contracts marriage with I, his mother or grandmother, how high soever, E, high daughter or granddaughter, how low soever, E, his sister, full consanguine, or IV, his niece or great niece, how low soever, V, his aunt or great aunt, it includes aunt from father's side or mother's side as well. The above categories of marriages are void on the ground of consanguinity. B. Affinity. A Muslim is prohibited from marrying with all such relative women with whom he has relationship of affinity. In case any marriage is done with any of the following relations, it is deemed, in law, as void. I. Wife's mother or grandmother, how high soever. E. Wife's daughter or granddaughter, how low soever. E. Son's wife or son's son's wife, how low soever. A woman can also not marry with her daughter's husband or daughter's daughter's husband. The above category of marriages are prohibited due to the violation of the rules of affinity. In Fatima by Ammal vs. A. Muhammad Mohideen 1971-2, M.L.J. 451, it was observed that the law imposes certain prohibitions based on consanguinity and affinity. If a man marries a woman in violation of such prohibition, the marriage is void and the offspring is illegitimate. There is Quranic injunction also against a man having at the same time two wives who are so related to each other by consanguinity, affinity or fosterage that if either of them had been male they could not have lawfully intermarried, as for instance two sisters or aunt and niece. E. Fosterage. When a child under the age of 2 years has been suckled by a woman, other than its own mother, the woman becomes the foster mother of the child. It is as much a prohibition in marriage as consanguinity because the act of suckling is regarded as equal to the act of procreation. For example, man is prohibited from marrying his foster mother's daughter. But under Sunni law one can marry 1. Foster sister's mother or sister's foster mother. 2. Foster son's sister. 3. Foster brother's sister. 4. Foster brother's mother. 5. Foster sister's foster mother etc. The Shias refuse to recognize the above exceptions because they place fosterage and consanguinity on the same footing. Under Shia law, the marriage with any of the foster relations is void without any exception. Irregular marriages, fasid. Certain kinds of marriages in Muslim law are called irregular, fasid, though their validity is not affected. The following marriages are considered as irregular. I. Marriage without witnesses. E. Marriage with a woman undergoing iddat. E. Marriage prohibited by reason of difference of religion. IV. Marriage with two sisters or contrary to the rules of unlawful conjunction. V. A marriage with fifth wife. V. Marriage done in intoxication. V. Marriage done with the non-kitabi woman. V. Marriage with the consent of guardian. X. Marriage of a Muslim woman with a non-Muslim. There are certain other grounds on the basis of which a marriage becomes irregular. They are: 1. The doctrine of equality in marriage. If there is unequal status of husband in comparison to the status of his wife, the marriage is irregular. In Hanafi law, these factors are considered necessary for determining equality. A. Family. B. Islam. C. Profession. D. Freedom. A. Good character. F. Means. 2. Illicit intercourse. If a person does illicit intercourse with a woman or commits an act of undue familiarity, it is not deemed valid in Muslim law. Some women's relations are forbidden to him although he may marry the woman herself. 3. Pilgrimage. Ithana Ishri and Shafi's school are of the opinion that he who comes from sacred places like Kaaba, and put on pilgrim's dress, may not enter into a contract of marriage while on the pilgrimage. 4. Divorce. If a Muslim divorces his wife once, he cannot remarry with such woman, wife. She will have to marry some other man after completing the period of iddat, and such marriage must be consented. After the consummation of such marriage she must be divorced, and only then she can remarry with her former husband. Legal effects. 1. Irregular marriage has no legal effect if it has not been consummated. 2. Consummation affects marriage. Q. 13 Akbar, an NRI resides in London, offers to marry Wahida in Delhi by long-distance call over the phone. Wahida accepts the offer on phone. Is this a valid marriage under Muslim law? Discuss. Ans. The essentials of a valid marriage under Mohammedan law is described in section 252 at page 224 of Mullah's Principles of Mohammedan Law, 19th edn. As it is essential to the validity of a marriage that there should be a proposal made by or on behalf of one of the parties to the marriage, and an acceptance for the proposal by or on behalf of the other, in the presence and hearing of two male or on male and two family witnesses, who must be sane and adult Mohammedan. The proposal and acceptance must both be expressed at one meeting. A proposal made at one meeting and an acceptance made at other meeting do not constitute a valid marriage. In the case in hand, the offer and acceptance have not been made in the presence and hearing of witnesses. Therefore, the marriage cannot be said to be valid. However, a marriage contracted without witness is irregular and not void under Sunni law. Such marriage can be validated by consummation. Under Sunni law, the presence of witness is not necessary in any matter regarding marriage. Q. 14 State concisely what do you understand by option of puberty of a Muslim girl? Ans. The marriage in Muslim law is a civil contract. Therefore, competency of the parties to marriage with regard to their age is one of the essential requirements. However, in case of a minor, the consent of marriage of a girl or a boy can be given by respective guardian on their behalf. It, however, does not mean that contract of marriage entered into by guardian of a minor on his or her behalf will finally be imposed on such minor throughout his or her life. Muslim law gives power to minor to repudiate or continue his or her marriage if he or she so likes after attaining the age of majority. Such right is called the option of puberty, Khairul Bulf. Thus option of puberty is the right to a minor boy or girl whose marriage has been contracted through guardian, to repudiate or confirm the marriage on attaining puberty. Old law of option of puberty. In old law, if the marriage of minor had been contracted by his, her father or grandfather, she had no right to repudiate the marriage after attaining the age of puberty. Present law on option of puberty. The above said disability in old law has been removed by Section 2(7) of Dissolution of Muslim Marriage Act, 1939, which provide as under. A woman married under Muslim law shall be entitled to obtain decree of divorce on the ground that she, having been given in marriage by her father or other guardian before she attained the age of 15 years, repudiated the marriage before attaining the age of 18 years, provided that the marriage has not been consummated. Time of option of puberty. For the sake of convenience, man's or woman's life can be divided into 3 stages, for understanding time for exercising the option of puberty. Sagir. It is the first stage when the boy or girl is below 7 years of age. In this stage the marriage is void ab initio. Sarir. It is the second stage when his or her age is above 7 years but below 15 years. In this stage though he or she can be married, but his or her consent for marriage is not recognized. He or she can validly be married only by his or her guardian. Bulugh. It is the third stage when he or she is above 15 years of age. It is now when he or she can enter into contract of marriage on his or her own free consent. In case of a girl who is aware of her marriage, she must exercise her right to the option immediately on attaining puberty. Any unreasonable delay would deprive her right of option. But if she does not know that she has this right, then it is prolonged until she is acquainted with the fact that she has such right. The option of puberty can be exercised through substantive suit filed by wife. But she cannot exercise such option when her husband has filed suit for restitution of conjugal rights. The option is lost if she, after having attained puberty, permits the marriage to be consummated. A male has the same right of option of puberty. This option can be ratified by him on attaining puberty by I. Express declaration. E. Payment of dower. E. Cohabitation. Q. 15 Najma, a Muslim girl, was married to Ahmed when she was 13 years old. After 6 months she went back to her father's house and refused to come back to Ahmed's house. Ahmed filed a petition for restitution of conjugal rights. Nazma pleaded she is no longer his wife, as immediately on attaining the puberty she had repudiated the marriage with him. In rejoinder, Ahmed pleaded consummation of marriage and stated that she had lost the right of option to repudiate the marriage on attaining puberty. Decide who will succeed. Give reasons. Ans. Under Muslim law, a boy or girl who has not attained puberty is not competent to enter into a contract of marriage, but he or she may be contracted in marriage by his or her guardian. When a minor has been contracted in marriage by the father or father's father, the contract of marriage is valid and binding, and it cannot be annulled by the minor on attaining puberty. When a marriage is contracted for a minor by a guardian other than the father or father's father, the minor has the option to repudiate the marriage on attaining puberty. By the Dissolution of Muslim Marriages Act, 1939. All restrictions on the options of puberty in the case of a minor girl whose marriage has been arranged by a father or grandfather have been abolished. And under Section 2(v) of the Act, a wife is entitled to the dissolution of her marriage if she proves the following facts, namely, 1. The marriage has not been consummated. 2. The marriage took place before she attained the age of 15 years. And 3. She has repudiated the marriage before attaining the age of 18 years. Puberty, under Mohammedan law, is presumed, in the absence of evidence, on completion of the age of 15 years. It would, therefore, necessarily follow that the minor should exercise the option after the age of 15 years, unless there is evidence to the contrary that puberty had been attained earlier, and the burden of proving this shall lie upon the person so pleading. Anything done by the minor during the minority would not destroy the right, which can accrue only after puberty. The cohabitation of a minor girl would not thus put an end to the option to repudiate the marriage after puberty. The assent should come after puberty and not before, for the simple reason that the minor is incompetent to contract, nor should the consummation have taken place without her consent. Therefore, the consummation of marriage before attaining the age of puberty does not destroy the right of Nazma to repudiate the marriage after she has attained the age of puberty. Q. 16. A Muslim girl is given in marriage by her father. When she attained the age of 17 years, she repudiated the marriage and brought a suit for dissolution of her marriage. What facts she is required to prove in order to succeed? Can the husband successfully resist the suit on any ground? Would it make any difference if the party repudiating the marriage is the husband? Ans. Before the enactment of the Dissolution of Muslim Marriages Act, 1939, a minor girl given in marriage by the father or the father's father had no option to repudiate it on the attainment of her puberty. But after the passing of the said act, the contract of the father or the father's father stands on no higher footing than that of any other guardian, and the minor can repudiate or ratify the contract made on her behalf during the minority. After the attainment of puberty. Section 2(7) of the Dissolution of Muslim Marriages Act, 1939 provides as under. A woman married under Muslim law shall be entitled to obtain a decree for the dissolution of her marriage on any one or more of the following grounds, namely, v. that she, having been given in marriage by her father or other guardian before she attained the age of 15 years, repudiated the marriage before attaining the age of 18 years, provided that the marriage has not been consummated. So Section 2(v) of the above Act has removed the restriction on the exercise of the option of puberty in the case of a minor girl whose marriage has been arranged by her father or grandfather. It has no effect in the case of a minor male given in marriage by his father or grandfather. In other words, when a minor male has been contracted in marriage by his father or grandfather, the contract of marriage is valid and binding, and it cannot be repudiated by the minor male husband on attaining puberty. However, if he is given in marriage by any other guardian, he, husband, can exercise his option of puberty until he has ratified the marriage either expressly or impliedly, as by payment of dower or by cohabitation. Q. 17. What do you understand by a valid retirement? Describe its legal effect. Ans. Valid retirement. The consummation of marriage is one of the essential requirements of a valid Muslim marriage. A presumption of such consummation of marriage can be raised only as-Sahih. The term valid retirement or Khilwat-ul-Sahah has been defined by the various jurists and the doctors of the Muslim law. Some of the important definitions are as follows. Radha ul Mukhatr said that, if the parties having no physical, moral or legal bar, retire into privacy, it raises a presumption of consummation of marriage. According to Fatwa Ilmgiri, a valid retirement is equivalent to the actual consummation for the various purposes. Amir Ali defined it in these words: when the husband and wife are together at a lonely place under such circumstances which present not legal, moral or physical impediments to material intercourse, they are said to be invalid retirement. The retirement will not be valid under the following circumstances. 1. When the parties are observing the obligatory fast of Ramzan. Or 2. Either husband or wife is suffering from an illness or physical incapacity which prevents connubial relationship. Or 3. A third person is present in that room even though such person is blind. Or 4. Any other legal, moral or physical impediments which cause or likely to cause disturbance in free intercourse between the spouses. Therefore, as per Amir Ali, merely the retirement into the nuptial chamber is not sufficient to give rise to the presumption of consummation of marriage. More particularly when the place for that purpose is exposed to public view or it has a public access, or if it is open, unenclosed place, the presumption of consummation of marriage does not arise. What actually needed for a valid retirement is the absolute privacy for the spouses. Legal effect of the valid retirement. According to Fatwa Ilmgiri, a valid retirement is equivalent to actual consummation for the purpose of I. Confirmation of dawah, e. Establishing paternity, e. Observation of iddat, iv. Observance of time in repudiation of marriage. It is, however, not applicable for the following purposes. A. For making a person musan, or a daughter unlawful. B. For making the divorced woman lawful to her first husband. C. For revoking repudiation of marriage. D. For inheritance. A. Replacing actual consummation for the purpose of impairing virginity. Amir Ali said that if a man should retire with a virgin and then repudiate her, she would subsequently marry as virgin. Q. 18. What do you understand by muta marriage? Describe its legal effects. Also distinguish muta marriage with valid, sahih, marriage. Ans. Muta marriage. Muta is a kind of temporary marriage recognized in the Shia school of Muslim law. The term muta implies enjoyment or use. Muta marriage is a marriage for a temporary but a fixed period after specifying dawah. According to Heffernan, in its legal context it may be rendered as a marriage for pleasure. It is not recognized in Sunni law because according to this school the marriage contract should not be restricted in its duration and the words used at the time of proposal and acceptance must denote an immediate and permanent union. Thus, under Sunni law, a marriage specifically declared for a limited period is void, but under Shia law such marriage is valid. Essentials of muta marriage. 1. The period for which the union is to last should be fixed at the time when the muta is contracted. It may be for a day, a month, a year or for a number of years. 2. Some dawah should be specified in the contract. If the term of the cohabitation is not specified but the dawah is fixed, the contract would be void as muta but may be valid as nikah. But if dawah is not fixed, neither muta nor nikah is valid. Therefore, where the term of the marriage was not fixed, it is not muta, and as also the dower is not fixed, the nikah is also not there. Therefore the cohabitation is illegal and no legal effects of such a marriage will be there. It is essential for a muta that the period must be fixed, though the marriage is temporary. According to Bailey, the rule of limiting the number of wives to 4 as regards regular marriage does not apply to muta marriage. Legal incident of a muta marriage. The legal incidents of a muta marriage are as follows. I. It does not confer on the wife or husband mutual rights of inheritance, but children conceived while it exists are legitimate and capable of inheriting from both parents. E. Where cohabitation originates in a muta marriage, but there is no evidence as to the original term for which muta marriage was contracted, or the cohabitation continue after the fixed period expires. The proper inference is that muta continued during the whole period of cohabitation and the children conceived during such period are legitimate. E. If the muta marriage is not consummated, the wife is entitled to half of the dower. IV. If the marriage is consummated, the wife is entitled to full dower even if the husband puts an end to the marriage before the expiry of the fixed term by making a gift of the term to her. V. If the wife leaves the husband before the expiry of the fixed term, she is entitled to the proportional dower only. V. A muta marriage does not entitle the wife to maintenance under her personal, Shia Mohammedan, law. V. If the children are born out of such marriages, they are legitimate and have the right of inheritance from both the parents. V. The marriage is dissolved if so facts on the expiry of the fixed period or by mutual consent. How dissolved? A marriage is dissolved. A. Automatically by the expiry of the term fixed, or B. At any time by the husband, making a gift of the term, to the wife even before the expiry of the term. This gift is known as hiba-i-muddan. Difference between muta marriage and nikah. Differences between regular marriage, nikah, and muta marriage are as under. 1. The regular marriage, nikah, is recognized by Shias and Sunnis both, whereas muta marriage is recognized only by Shiites. 2. Marriage or nikah is a permanent contract while muta marriage is temporary and a time-being enforceable contract. 3. Regular marriage gives a right of inheritance to spouse on the property of each other, while in muta marriage it is not so. 4. The relation once established between a wife and husband due to regular marriage is dissolved only on divorce or death of any of them, whereas muta marriage is automatically dissolved on the expiry of the specified period. 5. The woman becomes entitled to get the full amount of dower no sooner her regular marriage is solemnized properly. But the payment of dower, meher, in muta marriage depends upon the consummation of such marriage. In case marriage is not consummated in muta marriage, the wife is entitled only for half dower. 6. Regular marriage can be dissolved only through divorce and the payment of dower is very necessary before doing so, but in case of muta marriage, it can be terminated only on the expiry of the prescribed time. 7. The dawah can either be expressed or implied in regular marriage, while in muta marriage, it is always expressed. 8. In case divorce takes place after some time in the regular marriage, the wife is entitled to get maintenance during the period of iddat, while in muta nikah, a woman has no right to take any maintenance after dissolution of such marriage. Q. 19. It is often said that Muslim marriage is a civil contract. Can parties to this contract put any condition to contract they like? Discuss. Ans. Marriage among Hindus to a sacrament tie between man and woman. A sacramental marriage is considered to be holy union between man and woman for the performance of religious and spiritual duties. However, marriage under Muslim law is not essentially a sacrament but is a civil contract. Every Mohammedan of sound mind who has attained puberty may enter into contract of marriage. Muslim marriage being civil contract involves essential requirement of proposal made by one and acceptance of proposal by other party to marriage, ijabo kabul, at one meeting in the presence of two male or one male and two female witnesses. It is also necessary under Muslim law that the parties contracting a marriage must be acting under their free consent. Muslim law puts certain expressed prohibitions in respect of marriage. Muslim marriage also involves essential condition of payment of dawah, mahar, by husband to his wife in consideration of marriage. Such dawah, mahar, may either be prompt, muajjal, or deferred, muajjal. So Muslim marriage, basically is a civil contract. Since marriage among Mohammedans is a civil contract, it is possible for the parties to attach reasonable conditions to matrimonial contract. So much so that on breach of any of these conditions the court will have power to enforce the premarital agreement provided the conditions are not against public policy or opposed to principles of Islam. Where the parties to marriage are minor or lunatic, the agreement may be made on their behalf by their respective guardians. So if the agreement is not against the public policy or against the principles of Islam, it is legal and enforceable. Thus an agreement made before or after the marriage by which it is provided that wife shall be at liberty to divorce herself if husband contracts second marriage without her consent. Such agreement is valid and enforceable because it is not against public policy or is not opposed to Islamic principles. Similarly, premarital agreement between husband and wife that husband shall immediately on marriage will pay certain amount of dowry and will keep on giving his earning to his wife, and husband will take his wife to her parental house 4 times in a year, are valid and enforceable because it is not opposed to Islamic principles. However, any agreement providing for future separation or taking away husband's freedom to pronounce divorce are not enforceable since such agreements are in violation of Islamic principle. Q. 20a. Explain the validity of following agreements entered into between husband and wife at the time of their marriage under Mohammedan law. I. That the parties shall not follow the Muslim law of inheritance. E. That the husband shall have no right to divorce the wife. B. M. A Sunni Muslim marries W. A Sunni female without the presence of any witness. Will it make any difference if the parties were Shias? Ans. A. Muslim marriage is a civil contract. It is possible for the parties to attach reasonable conditions to the matrimonial contract, so much so that on breach of any these conditions the court will have power to enforce the premarital agreement, provided the conditions are not against public policy or against the principles of Islam. Thus, conditions of marriage contract may be classified into I. Legal and E. Illegal. Legal conditions are valid and enforceable, and illegal conditions are such as to affect the validity of the contract and render the contract of marriage voidable unless consummation takes place in. If consummation takes place, the condition alone is void. Now coming to case in hand. I. An agreement that parties shall not follow Muslim law of inheritance is in contravention of Section 2 of the Shariat Act 1937, therefore it is illegal and thus not enforceable. E. A stipulation negativing the husband's freedom for pronouncing divorce is illegal because such condition is against the principles of Islam. B. Under Muslim law, solemnization of marriage requires certain essential forms and formula. These essentials are that there should be a proposal made by or on behalf of one of the parties to the marriage and acceptance of the proposal by or on behalf of the other, in the presence and hearing of witnesses who must be sane, adult and Muslim. This proposal and acceptance must be made at one meeting. Under Sunni law, the proposal and acceptance must be made in the presence of 2 male or 1 male and 2 female witnesses. Absence of witnesses does not render the marriage void but voidable. Under Shia law, witnesses are not necessary at the time of marriage. However, when the guardian of a minor contracts marriage on his or her behalf, such marriage requires 2 adult witnesses. Therefore, marriage between M and W is not void but only voidable. Q. 21. Explain the concept of iddat under Muslim law. Ans. Iddat is the period during which it is incumbent upon a woman whose marriage has been dissolved by divorce or death of her husband to remain in seclusion and to abstain from marrying another husband. So iddat is an interval which the woman is bound to observe between the termination, by death or divorce of one matrimonial alliance and commencement of other. Object of iddat is to ascertain the pregnancy of wife so as to avoid confusion of parentage. Under Sunni law, marriage with woman undergoing iddat is irregular and not void. But under Shia law, marriage with woman who is undergoing iddat is void. So iddat is described as a period during which a woman is prohibited from marrying again after the dissolution of her first marriage. Object of iddat is to ascertain the pregnancy of the wife so as to avoid the confusion of parentage. Duration of iddat. I. Iddat of talaq, period of iddat. In case of marriage being dissolved by talaq, divorce, is that if woman is subject to menstruation. 3 courses. Otherwise, if she is not subject to menstruation, it is 3 lunar months. If woman is pregnant at the time of divorce, the iddat will not terminate till delivery. E. Iddat of widowhood. When a person dies leaving a widow, she is prohibited from marrying before the expiration of 4 months and 10 days. E. Iddat of pregnant widow woman. Important point here is that if marriage is not consummated, iddat has to be observed in the case of death but not in case of divorce. Under Sunni law, marriage with a woman undergoing iddat is irregular and not void. But under Shia law, marriage with a woman who is undergoing iddat is void. Q. 22. Discuss the validity or otherwise of the following. A Sunni male marries a Shia woman in a desert where there are no witnesses. B. Marriage of a Shia woman was dissolved on January 1, 1980 on account of death of her husband B. The marriage was not consummated. A married D on January 26, 1980. C. A Shia married B, a Shia female in the presence of a witness Q on January 12, 1980. In June 1980 he married D, who was B's sister. D. A Sunni male marries B, a Sunni female, but no mahar was specified. Under the Muslim law, marriage is a civil contract. Marriage, nikah, literally means the union of the sexes, and in law this term means marriage is a legal process by which the sexual intercourse and procreation and legitimation of children between man and woman is perfectly lawful and valid. According to Dr. Jung, marriage, though essentially a contract, is also a devotional act. Its object are rights of enjoyments and procreation of children and regulation of social life in interest of society. It is essential amongst the Sunnis that at least 2 male witnesses or 1 male and 2 female witnesses must be present at the time of proposal and acceptance of marriage contract between bridegroom and bride. However, absence of witnesses does not render the marriage void, but voidable, and could be validated by consummation of marriage. Under Shia law, witnesses are not necessary at the time of marriage. So marriage in present problem is valid if consummated or voidable if not consummated. B. Among Muslims, it is incumbent upon a woman whose marriage has been dissolved by divorce or death of her husband to remain in seclusion and to abstain from marrying another husband for certain term, which is called iddat. So iddat is described as a period during which a woman is prohibited from marrying again after the dissolution of her first marriage. Object of iddat is to ascertain the pregnancy of the wife so as to avoid the confusion of parentage. Duration of iddat. Iddat of talaq, period of iddat, in case of marriage being dissolved by talaq, divorce, is that if woman is subject to menstruation. 3 courses otherwise, if she is not subject to menstruation, it is 3 lunar months. If woman is pregnant at the time of divorce, the iddat will not terminate till delivery. Iddat of widowhood. When a person dies leaving a widow, she is prohibited from marrying before the expiration of 4 months and 10 days. Iddat of pregnant widow woman. If the widow is pregnant at the time of death of her husband, iddat will not terminate until delivery or miscarriage. Important point here is that if marriage is not consummated, iddat has to be observed in the case of death but not in case of divorce. Under Sunni law, marriage with a woman undergoing iddat is irregular and not void. But under Shia law, marriage with a woman who is undergoing "iddat" is void. In present problem, marriage of A, the Shia woman, was dissolved by the death of her husband. Therefore, she is bound to observe "iddat" for period of 4 months and 10 days irrespective of fact whether marriage was consummated or not. But she married D before the expiry of period of "iddat", therefore, according to Shia law, her second marriage was void. C. Under Shia law, marriage prohibited by reason of unlawful conjunction is void. Unlawful conjunction means marrying two women so related to each other by consanguinity, affinity or fosterage, that they could not have lawfully intermarried with each other if they had been of different sexes. Thus Muslim cannot marry two sisters or an aunt and her niece. In present case, A has married with sister of her first wife who is alive and living with him, so marriage between A and D is void because parties were subjected to Shia law. Legal position under Sunni law is different on this point. Bar of unlawful conjunction renders the marriage under Sunnis irregular, not void. D. Mahar or dower is a sum of money or other property which the wife is entitled to receive from the husband in consideration of the marriage. Under the Mohammedan law, dower is an obligation imposed upon the husband as a mark of respect to the wife. The husband may settle any amount he likes by way of dower upon his wife, though it may be beyond his means, and though nothing may be left to his heirs after the payment of the amount. But he cannot in any case settle less than 10 dirhams. The main object of the dower is to protect the wife against the arbitrary exercise of power of divorce by the husband, and the amount of dower is often high. Therefore, the non-specification of mahar before or at the time of marriage shall not affect the validity of the marriage. Q. 23. Define dower. Explain its importance under Muslim law. Discuss different categories in which dower can be divided. Uns. Dower is anything, whether money or other property, which the wife is entitled to get from her husband in consideration of entering into marriage contract. According to Muslim law, marriage is a civil contract and dower is necessary result of it being a part of the consideration of her agreement to become her husband's wife by consummating the marriage. According to Amir Ali, dower is a consideration for his wife's sole and exclusive use and benefit. Bailey observed that the fact of marriage having been contracted involves as a necessary consequence that the wife can claim from the husband by way of consideration for the surrender of her person. According to Wilson, dower is a consideration for the surrender or person by the wife. It is the technical Anglo-Mohammedan term for its equivalent mahar in Arabic. According to Mullah, dower is a sum of money or other property which the wife is entitled to receive from the husband in consideration of the marriage. In MST Nasra Begum vs. Rijwan Ali, Hair 1980 All. 118, it was observed that under Mohammedan law, meher or dower means a sum of money or other property which the wife is entitled to receive from the husband in consideration of her marriage. However, expression, consideration, is not to be understood in the sense in which the word is used in the Contract Act. In effect, dower is an obligation imposed upon a husband as mark of respect for the wife. Normally the extent of such obligation is determined by the contract entered into between husband and wife, either before or at the time of marriage. It may be fixed after the marriage has taken place. If the amount of dower is not fixed or marriage has been performed on express condition that wife will not claim any dower, still, wife is entitled to receive proper dower, meher-i-misi. Nature. The following points may be noted with respect to the nature of dower. 1. Dower is not exactly a consideration for marriage in the sense of a consideration for any other contract. It is an obligation imposed by the law on the husband as a mark of respect for the wife. 2. It is a consideration for conjugal intercourse. The right to cohabitation comes into existence at the same time and by the reason of some incident of law as the right to dower. 3. Dower is an essential incident of marriage with the result that even if no dower is fixed, the wife is entitled to some dower from the husband. In fact, even a stipulation that a wife will not be entitled to any dower will be invalid. But the notion of dower given above is not correct. Fitzgerald says, it would be incorrect to describe Muslim dower purely as the bride's price. Classification of dower. The dower may be classified into 1. Specified dower, meher-i-musamma. Specified dower is again divided into A. Prompt dower, muajjal mahar. B. Deferred dower, muwajjal mahar. 2. Customary dower, meher-in-misal. 1. Specified dower. It is also called al-maral musamma. Specified dower is fixed at the time of marriage. The qazi who performs the ceremony of marriage enters the amount of dower in the register. The amount of dower is fixed either at the time of marriage or later on. In case the contract of marriage of a minor son is entered into by the father or guardian, the amount of meher so fixed by father or guardian is binding on the minor. There are difference of opinions amongst the various schools regarding determining the personal liability of father or guardian for dower on behalf of minor. According to Hanafi law, the father is not personally liable for the meher. However, in Ithna Ashari law, he is held responsible. In Sahir Hussain vs. Farjand Khan, Heir 1938 PC 80, it was observed, in case of minor husband, his father has power to make the contract of dower on minor's behalf and contract is binding on the husband and on attaining the age of majority. He cannot take the plea that he was not party to such contract. Where the dower is fixed by father or other guardian on behalf of minor boy. Under Sunni law he does not thereby render himself liable for its payment unless he stands as surety, and in case of Shia law whether the father is surety or not. If he contracts his minor son in marriage and the child is poor, the liability for dower rests entirely on father and in the event of his death, must be discharges out of his estate. When the dower is specified it may be payable, 1. On demand, or 2. On death of husband or divorce. The former is known as prompt dower, mahar-i-muajjal, and the latter is deferred dower, mahar-i-muwajjal. When dower is fixed, it is usual to split it into 2 equal parts and to stipulate that one shall be paid at once on demand and the other on the death of the husband or in case of divorce. A. Prompt dower. The following points must be noted regarding prompt dower. I. Prompt dower is payable immediately on the marriage taking place and it must be paid on demand, unless delay is stipulated for or agreed. It can be realized at any time before or after the marriage. E. Prompt dower does not become deferred after consummation of marriage and a wife has absolute right to sue for recovery of prompt dower, even after consummation. On the consummation of marriage, the only thing that goes against her is that she cannot resist the restitution of conjugal rights of the husband if the prompt dower has not been paid by him. Instead of refusing to decree the suit for restitution of conjugal rights to which she is entitled if marriage is consummated, the court may pass a conditional decree for restitution on payment of prompt dower. E. It is only on the payment of the prompt dower that the husband becomes entitled to enforce the conjugal rights, unless the marriage is already consummated. The right of restitution arises only after the dower has been paid. Until the marriage is consummated, the wife has a right to refuse him conjugal union unless the prompt dower is paid. IV. As the prompt dower is payable on demand, limitation begins to run on demand and refusal. The period of limitation for this purpose is 3 years. If during the continuance of marriage the wife does not make any demand, the limitation begins to run only from the date of the dissolution of marriage by death or divorce. B. Deferred dower. This is payable on dissolution of marriage either I. by the death of either of the parties or E. by divorce. In a case in which no specific proportion of prompt and deferred dower has been fixed by agreement at the time of the marriage or by custom, I. the whole is regarded as prompt according to Shia law. E. part is regarded as prompt and the remaining part is deferred according to Sunni law. The proportion is regulated by the status of the parties and the amount of the dower is settled. The court has however the power to award the whole as prompt. On the dissolution of marriage, I. if the marriage was consummated, the wife is entitled to the immediate payment of the whole of the unpaid dower, both prompt as well as deferred, and E. if the marriage was not consummated, she is entitled to only half of the specified dower. If the dower is not paid to the Muslim wife, she and after her death, the heirs may sue for it. The period of limitation for a suit to recover prompt dower is 3 years. In case of deferred dower, the period of limitation is 3 years, from the date when marriages is dissolved by death or divorce. 2. Customary or proper dower. When the amount of the dower has not been settled, or even when the marriage has been contracted on an express stipulation that the wife shall not claim any dower, she is entitled to proper or customary dower. Nasra Begum vs. Razwan Ali, 1980 Old, 118. It is also termed dower of her equals. It is at the discretion of the court as to what it considers proper dower for the woman, but the court is generally to be guided by these considerations. I. The social position of the family of woman's father. E. her own personal qualification, e. the powers that have been given to her female paternal relations, i.e., her consanguine sisters, her paternal aunts, the daughters of her paternal uncles or her father's sisters. IV. The position of the husband must not be altogether excluded from consideration as unequal marriage often take place. Azimuddin vs. Bibi Husani, 1942 AWR 110. V. When a wife bases her claim on a contract which she fails to establish, the court is bound to decree such amount as dower as is admitted by her husband. 7 La. 447. Shia law. Under Shia law, the proper dower should not exceed 500 dirhams. 500 dirhams was the amount fixed as dower on the marriage of Fatima, the Prophet's daughter. Q. 24 Explain the widow's right of retention in lieu of her dower debt in Muslim law. Ans. Dower or mahar is a sum that becomes payable by husband to the wife on marriage either by agreement between the parties or by operation of law. Dower may be defined as sum of money or other property which the wife is entitled to receive from the husband in consideration of the marriage. It may be either prompt or deferred. Husband may settle any amount he likes by way of dower upon his wife, but he cannot in any case settle less than 10 dirhams. Jagdish Narayan Sharma vs. Katori Devi, 1994, 3, RCR 728, MP. Dower or meher can be defined as sum of money or other property which the wife is entitled to receive from the husband in consideration of marriage. However, gifts made to wife at the time of marriage are not part of dower or meher. Object of dower is threefold. Firstly, to impose an obligation on the husband as mark of respect of wife. Secondly, to put a check on capricious use of divorce on the part of husband, and thirdly and importantly, to provide for her subsistence after the dissolution of her marriage, so that she may not become helpless after divorce or death of her husband. Dower ranks as a debt and the wife is entitled along with other creditors to have it satisfied on the death of the husband out of his estate. If the widow has lawfully and without force and fraud obtained in lieu of her dower actual possession of the property of deceased husband, she is entitled to retain that possession as against other heirs and as against other creditors of her husband until her dower is paid. A widow's right to retain possession of her husband's estate in lieu of her dower is sort of compulsion to obtain speedy payment of the dower, which is an unsecured debt. Where she is not in possession or has lost possession, she cannot claim to obtain it because her right to retain is not in the nature of a charge on the property like mortgage but a personal right. In Main Bibi vs. Chaudhary Vakil Ahmad, 1924, 52 IA 145, Privy Council observed, possession of property once lawful acquired by Muslim widow. Right to retain it in lieu of dower until payment of dower is conferred upon her by the Muslim law. However, right of retention does not give her any title to the property, therefore she cannot alienate the property. In Sheikh Salma vs. Muhammad, Abdul Qadir, Air 1961 AP 428. It was held that widow in possession of her husband's property in lieu of dower debt is liable to account to other sharers of income from such property in her possession. Q. 25. What is the provision of Muslim law regarding the following issues connected with dower? A. Can the amount of dower be increased after marriage? B. Is it necessary to specify the amount of dower at the time of marriage? C. Is a Muslim wife entitled to any other dower when the specified dower is unlawful? D. Whether the contract of dower made by a father on behalf of his minor son make him, son, liable to pay such dower? A. Can a Muslim wife remit the whole or part of the dower in favor of her husband? If so, when and how? Ans. A. Increase or decrease of dower. A Muslim husband may increase the dower at any time after his marriage, but once the amount of dower is agreed by the wife and husband, it becomes a contract. Such contract then becomes binding on the husband. B. Determination of the specific dower. It is necessary in a Muslim marriage that the amount of dower, meher, should be specified. In case it is not done so, the legality of the marriage is not adversely affected due to the same. If the amount of dower is not specified at the time of marriage, it can be determined in proportion to amount of dower given to the other woman of the bride's house. C. Entitlement of a Muslim wife for other dower. If the amount of dower, meher, in a Muslim marriage is unlawful, the marriage itself will not be invalid or void. It is a general rule that the amount of dower for Muslim wife will be fixed on the basis of social position of her father's family and her own personal qualifications. D. Liability of son to pay dower fixed by his father. If contract of marriage of Muslim minor is entered by his or her father or guardian, the amount of dower fixed in consideration of marriage becomes binding on the boy, bridegroom. In case such father or guardian stood as security for the payment of such dower, he can be held liable to pay the same in case the boy, bridegroom, fails to do so. A. Remission of meher by wife. A Muslim wife can remit the dower or any part thereof in favor of the husband or his heirs. Even if such remission is without consideration, it is held valid in the eye of law. In this connection it is, however, necessary that the remission must have been made with the free consent. Free consent, in reference means A. Without coercion, or B. Undue influence. In the case of Nuranessa vs. Khoje Muhammad, 1930, 47. Cal 537, it was held by the court that if the remission of dower is made by the wife when she is in a great mental distress owing to her husband's death, it will not be deemed to have been done with free consent of wife. It is also necessary that remission of dower must be made only by such a wife who is not minor. According to Allahabad High Court in the case of Qasim Hussain vs. Bibi Kaniz, 1932. 54 All 806, that Indian Majority Act, Section 2, 1875 does not affect on the capacity of only or any person to act in the matter of marriage or dower. Therefore, a Muslim girl who has attained the puberty is competent to relinquish her dower, though she may have not attained the age of majority, 18 years, within the meaning of Indian Majority Act. This view is correct as per Mullah Q. 26. A Sunni widow who was a convert to Islam, sued the heirs of her husband for recovery of 51,000 rupees as her dower, alleging that this was the amount fixed at the time of marriage. The heirs pleaded that she was a concubine and not a married wife. The court found the marriage to be proved but held that the dower alleged by her was not proved. What decision would you record in respect of the amount of dower, if any? Ans. 3 things are to be noted in this case. They are: A. The marriage has been proved. B. Dower has not been proved. C. She was a convert to Islam and hence a non-Muslim before marriage. When the marriage has been proved, she become entitled to dower. But the dower has not been proved, in other words, it is not specified. Hence, in the absence of specified dower she becomes entitled to proper dower, which is to be fixed at the discretion of the court. Ordinarily, for its guidance in exercising this discretion, the court should consider the dower usually settled on to her female members of her father's family. But in this case, the widow being a convert, the court can have no such guidance because the female members of her father's family were non-Muslims. The only alternative is to fix an amount considered reasonable with reference to the means of the husband and the status of the wife. Q. 27. What are the remedies open to the wife on non-payment of dower? Ans. The rights which dower confers on the wife are threefold. 1. Refusal to cohabit. 2. Right to dower as a debt. 3. Retention of husband's property. 1. Refusal to cohabit. If the marriage has not been consummated, she has a right to refuse to cohabit with the husband so long as the prompt dower is not paid. Before consummation, the wife is entitled to refuse to live with her husband and refuse to him sexual intercourse so long as prompt dower is not paid to her. In a suit for restitution of conjugal rights by the husband, the non-payment of prompt dower is a complete defense if the marriage is not consummated. If the wife is minor or insane, her guardian can refuse to allow the husband to take her with him till the payment of prompt dower. If the minor wife is already in her husband's custody, such guardian can take her back on the ground of non-payment of prompt dower. Nasra Begum vs. Razwan Ali. AIR 1980 Old. 118. If the marriage has been consummated, she cannot refuse to cohabit provided the consummation took place when she was no more a minor or an insane. The absolute right of the wife to insist on payment of the prompt dower before giving him the access to her, is lost after the consummation of marriage. After consummation, the husband's suit for restitution would be dismissed, but the court may pass decree of restitution on condition of payment of prompt dower. 2. Right to dower as a debt. The dower ranks as a debt and the wife is entitled, along with the other creditors, to have it satisfied on the death of the husband out of his estate. The Privy Council in the case of Amirun Nisa vs. Morad Unnissa, 1855, held that the dower ranks as a debt and the widow is entitled to have it satisfied along with the other creditors. In case of death of her husband, out of his estate. 3. Retention of her husband's property. A widow's right to retain possession of her husband's estate in lieu of her dower is sort of compulsion to obtain speedy payment of the dower, which is an unsecured debt. Where she is not in possession or has lost possession, she cannot claim to obtain it because her right to retain is not in the nature of a charge on the property like mortgage but a personal right. In Main Bibi vs Chaudhary Vakil Ahmad, 1924-52 IA 145, Privy Council observed, possession of property once lawful acquired by Muslim widow. Right to retain it in lieu of dower until payment of dower is conferred upon her by the Muslim law. However, right of retention does not give her any title to the property, therefore she cannot alienate the property. Q. 28 Discuss the principle underlying talaq. How is it made? Ans. What is talaq? The word talaq originated from the word talaka, which means to release an animal, and talaq is releasing wife from the bondage of marriage. Talaq means the exercise of the absolute power which the husband possesses of divorcing his wife at all times. According to Muslim law, any husband, who is of sound mind and has attained puberty, may divorce his wife whenever he desires without assigning any reason, at his mere whim or caprice. Under Shia law, free will and intention are essential for valid talaq, which is not necessary under Sunni law. It may be oral or in writing. In India, no decree of court is necessary for making the talaq effective. But in many Islamic countries of the world, this arbitrary power of the husband has been controlled to a large extent by reforming the Islamic law on this point. Thus, in Turkey, Cyprus, Tunisia, Algeria, Iraq and Iran, a husband desiring to divorce his wife has to apply to a court of law. Sunni law, oral talaq. The husband may give talaq by mere words without any talaqnama or deed of divorce, and no particular form of words is necessary. If the words are express and well understood as implying divorce, no proof of intention is required. If the words used are ambiguous, the intention of the user must be proved. The words, "I have divorced thee," or "I divorce my wife forever and render her haram for me," clearly indicate an intention to dissolve the marriage, and no proof of intention is necessary. But the words, "Thou art my cousin, the daughter of my uncle, if thou goest," or "I give up all relations and would have no connection of any sort with you," are ambiguous, and as such, the intention must be proved. Talaq given in the absence of wife. It is not necessary that the talaq should be pronounced in the presence of the wife or even addressed to her. The absence of wife does not make it void or ineffective, but in case of her absence, she must either be referred to by name or the words of repudiation must clearly refer to her. Hence, where merely the words of divorce alone were pronounced, the talaq was held to be invalid. The talaq given in the absence of the wife must be communicated to her within a reasonable time. Talaq in writing, talaqnama. A talaqnama may only be the record of the fact of an oral talaq, or it may be the deed by which the divorce is effected. Talaqnama may be executed in the presence of the qazi, or of the wife's father or of other witnesses. Wife's presence is not necessary. If the deed is properly subscribed and addressed or is in a customary form, intention is not necessary to be proved. If it is ambiguous or words are unintelligible, the intention must be proved. Divorce by talaqnama takes effect from the date of the document and not from the date of its receipt by the wife. Talaq under compulsion or intoxication or in jest, Sunni law. A. Talaq is valid and effective even if pronounced under compulsion. Hence, a talaq given by husband to please his father, in spite of the fact that the husband did not intend to divorce his wife, was held to be valid. Rasid Ahmad vs. Anisa Khatun, 1931-59 I-821. B. Talaq given under intoxication is also valid unless the drug was given against his will. C. A talaq uttered in sport or jest or by mere slip of tongue is valid. Shia law. A talaq under Shia law must be pronounced orally in the presence of two competent witnesses. A talaq communicated in writing is not valid, unless the husband is physically incapable of pronouncing it orally. Talaq under intoxication, jest or compulsion is not valid in Shia law. The particular form of talaq must be pronounced in Arabic language, unless the husband has no knowledge of this language, in which case it must be pronounced in his mother tongue. In Dilshada Masood vs. G.H. Mustafa, AIR 1986 Jammu and Kashmir 80, the High Court of Jammu and Kashmir held that under Shia law, divorce must be pronounced only in Arabic and that too in a specific form. It is not, however, necessary that the husband himself must be knowing Arabic. He can engage the services of an agent who knows Arabic to pronounce the same in his behalf. It was also observed that it is an established principle of Shia law that pronouncement of talaq must be uttered orally in presence and hearing of two male witnesses who are Muslims. However, it is nowhere written in any texts of Shia law that divorce must be pronounced in presence of Imam. Written talaq, talaqnama, is not valid in Shia law, unless husband is dumb or otherwise incapable of speaking. Talaq in the absence of wife is valid under Shia law also provided name of wife is expressly referred to in pronouncement of talaq. Q. 29 What are revocable and irrevocable divorces under Muslim law? Can the parties to these divorces remarry? Ans. Under the Muslim law, a marriage is dissolved either by death of husband or wife or by divorce. Divorce can be classified in following. Divorce by husband: I. Talaq, E. Ila, E. Zihar. By wife: Talaq tafwiz, by mutual consent: I. Khula, E. Mubarak. By judicial decree, under Dissolution of Muslim Marriage Act 1939. In order to pronounce a valid talaq, husband under Shia law must be of sound mind who has attained the age of puberty is competent to pronounce talaq. The pronouncement must be in presence of at least two witnesses, and under Sunni law every Muslim man is capable of giving talaq who is adult and sane. Talaq may be effected in any of the following modes on revocation point of view. 1. Talaq ul Sunnat. 2. Talaq ul Bidhat. 1. Talaq ul Sunnat. It has been subdivided into A. Ihsan, B. Hasan. A. Ehsan talaq in ehsan form is very best kind of talaq. To be in ehsan form, the proceedings of divorce must satisfy following conditions. I. Husband must pronounce the formula of divorce in a single sentence. E. Pronouncement of divorce must be in state of purity. E. Husband abstain from intercourse for the period of iddat. A pronouncement made in ehsan form is revocable during iddat, and becomes irrevocable on expiry of period of iddat. B. Hasan. To be in Hasan form, the proceedings must satisfy following conditions. I. There must be 3 successive pronouncements of formula of divorce. E. In case of menstruating wife, the first pronouncement should be made during the state of purity, and the second during next state of purity and third on next. E. In case on non-menstruating wife, pronouncement should be made during the successive intervals of 30 days. IV. No sexual intercourse should take place during these periods of state of purity. Such divorce becomes irrevocable on third pronouncement, irrespective of iddat. 2. Talaqul biddat. It is most irregular form of mode of talaq. Sunni law recognizes such mode of talaq, but they think it to be sinful. Shias do not recognize this form of divorce. Following are the requirements in talaqul biddat. 3 pronouncements made during single period of purity, in one sentence. Such talaq becomes irrevocable immediately when it is pronounced irrespective of iddat. Under the talaqul biddat, once a definite complete separation has taken place, then parties so separated cannot remarry without the formality of the woman marrying another man and being divorced from him. Ali Muhammad vs. MST. Raymond Mio, 1972, PLR 869. Husband filed written statement in proceeding U.S. 488 CRP, C. stating that he had divorced his wife and nothing to do with her. Written statement held amounts to talaqul biddat. Q. 30. A. How talaq, divorce, takes place by the conduct of wife and husband. B. Distinguish between khula and mubarat. Ans. Divorce by the conduct of spouse. Marriage in Muslim law is a civil contract based on the mutual goodwill and cooperation of wife and husband. As such, either a Muslim wife or husband can take divorce by their conduct. In such cases, the following types of talaq can take place. 1. Khula. 2. Mubarat. 1. Khula. Sometimes the divorce of a spouse takes place with the mutual consent of both the parties. The word khula literally means to take off clothes and thence to lay down one's authority over a wife. Prior to Islam, the wife had no right to ask for the divorce. Such a right was conferred upon her only through Quranic legislation. It has been written in Fatwa, I-Almgiri, that when married parties disagree and they are apprehensive, they cannot observe the bounds prescribed by the divine laws. I.e., when the duties imposed on the spouse on account of their conjugal relations cannot be performed, the wife can release herself from the tie of her marriage by giving up some property in return. In consideration of it, the husband has also to give her a khula. This practice is adopted in the case of talaq ul bain. This form of divorce has been recognized in Section 28 of Special Marriage Act, Act 43 of 1954. Essential conditions. The following are the essential conditions for khula. 1. Common consent of the husband and wife. 2. Some return, or consideration, lavaz, from the wife to husband, if she desires to separate her from husband through such divorce. The speciality of divorce by khula is that a wife begs from her husband to release her from the tie of marriage. b. Such request is made for certain consideration which is usually a part of whole of the meher. b. Mubarat. The term mubarat denotes the act of freeing one another mutually. In such a divorce, spouse feel happy at the prospects of getting rid of each other. In the divorce of mubarat, the offer for the dissolution of marriage may proceed from wife or it may proceed from the husband. However, once it is accepted, the dissolution of marriage is deemed complete and operates as a talaq-i-bain. The legal effect of khula and mubarat. The legal effect of khula and mubarat is that, once it is completed, the divorce between a spouse becomes irrevocable. A marital life, thereafter, cannot be resumed. A form called remarriage is then necessary. If iddat is incumbent on the wife, in absence of agreement to contrary, she and her children are entitled for maintenance during such period. Difference between khula and mubarat. There are following differences between khula and mubarat. Khula, mubarat. 1. When the desire for separation is expressed from the side of wife, it is called khula. 1. Where the desire for separation is expressed from any side, it is called mubarat. 2. Consent of husband is necessary. 2. Mutual consent is necessary. 3. It is effected by an offer from wife to compensate the husband, if she is released by him from the marital tie. 3. It can be effected by the offer of any of the spouse. 4. Consideration is essential for khula marriage. It may be whole or part of meher. 4. No such consideration. 5. The contract of marriage, if dissolved, is irrevocable. 5. Irrevocable. 6. The observance of period of iddat is necessary. 6. It is followed in mubarat also. Q. 31 is a stipulation between husband and wife conferring the right on the wife to divorce herself, permissible under Mohammedan law. If so, is it conditioned by prerequisites? What are the principles on which Mohammedan law recognizes such a stipulation? Ans. Marriage under Muslim law being essentially a contract. There can be an agreement between Muslim husband and wife providing that wife will be at liberty to divorce herself from her husband under certain specified conditions or contingencies. However, for the enforceability of such agreement, it is essential that conditions or contingencies in which wife will be entitled to divorce herself from her husband should not be opposed to public policy or to the principles of Islam. Under Muslim law, power to give divorce primarily lies with husband. Husband under an agreement made either before or after the marriage delegates this power to his wife. This is called talaq tawfiz. It must be borne in mind that in case talaq tawfiz, the wife does not divorce her husband as this she cannot do under Muslim law, but in fact she divorces herself on behalf of her husband under his powers delegated to her. When wife is empowered to divorce herself in specific contingencies, which she will exercise at the happening of any of them, the divorce will take effect to same extent as if it had been pronounced by the husband. In Baflatan Bibi vs. Abdul Salim, Hair 1950 Cal. 304, it was held that the wife exercising her power under the agreement must establish that the conditions entitling her to exercise the power have been fulfilled. Therefore, an agreement between husband and wife, whether entered into before or after the marriage, by which the husband authorizes the wife to divorce herself from him in the event of his marrying a second wife without her consent, is valid, because conditions are of reasonable nature and are not opposed to policy of Muslim law. Q. 32a. Two Muslims A and B were married on 18.6.85. It was agreed by the parties that if A took a second wife, B will have right to pronounce divorce on 20.4.87. Is it a valid divorce? Ans. A. Under Muslim law, husband can lawfully delegate his power to divorce his wife to any third person or even to his own wife to divorce herself. This concept is known as talaq taweez. According to this concept, the talaqi husband may enter into an agreement with his wife that under certain specified conditions wife would be at liberty to divorce herself from her husband. However, such agreement to be valid, it is necessary that option is not absolute and unconditional, and secondly, conditions are reasonable and not opposed to public policy. In Muhammad Khan vs. Shamali, Hair 1972 J&K 8 agreement, under which husband agreed to live in his wife's parental house, and if he would leave that house he would pay certain specified sum. Default of this condition would operate as divorce. It was held that the condition was not opposed to public policy. Violation of such term would operate as divorce between husband and wife. However, it is important to point out that in case of talaq taweez, the wife does not divorce her husband under his power delegated to her by him. Under Muslim law, when under the contract, the wife is empowered to divorce herself in specific contingencies which she exercises at the happening of any of them, the divorce will take effect to same extent as if it had been pronounced by the husband. So divorce pronounced by B to herself when a solemnized second marriage is not opposed to public policy and being talaq taweez is valid. Q. 33. A Muslim wife misbehaved with her husband. She was addressed thrice the word talaq, pronounced by her husband. Thereupon she apologized for her misbehavior. They continued cohabitation. A son was born to the woman from him. He was got admitted to the school by her father as his own son and brought him up as such. After the death of the man, his full brother laid exclusive claim to his estate. Decide the suit. The defenses raised are that divorce was revoked and that paternity of the son was acknowledged. Ans. Under Muslim law, one of the forms of talaq, divorce, is talaqul biddat. Such form of talaq is recognized under Sunni law, but is considered to be irregular form of talaq. Under Shia law, talaqul biddat is not recognized. In order to be in this form of talaq, following requirements are required. A. 3 consecutive pronouncements of talaq made during single period of purity, in one sentence. B. A single pronouncement of talaq made during indicating an intention to dissolve the marriage. Talaq in the form of talaqul biddat becomes irrevocable immediately when it is pronounced, irrespective of the fact that period of iddat has been undergone or not. Under the talaqul biddat, once a complete and definite divorce has taken place, parties to marriage cannot remarried without the formality of the woman marrying another man and being divorced from him. In the case hand, Muslim wife was given divorce in talaqul biddat form by her husband by pronouncing word talaq thrice to her. As stated above, such divorce becomes irrevocable immediately on the pronouncement of talaq 3 times in one sentence. Such talaq cannot be revoked by husband on apology by his wife for her misbehavior. Therefore, in the case in hand, marriage of husband and wife was dissolved by divorce. Parties could have remarry only when wife, after undergoing the iddat period, marries to another man and divorced by him also. But in this case, this formality has not been gone through by the parties, therefore, marriage between them stand dissolved, after the pronouncement of talaq by husband. However, facts of the case in hand indicate that after the apology by Muslim wife for her misbehavior, parties kept on living as husband and wife and continued cohabitation, and a son was born to woman from him. Son was got admitted in the school by Muslim husband, showing himself to be his father, and also brought up the son as such. After the death of Muslim husband, when brother of such Muslim husband filed suit claiming exclusive right over his estate, question of legitimacy of son is raised. As stated above, a irrevocable talaq had taken place between Muslim husband and wife. Therefore, if even after the talaq parties cohabit and son has born, such son will not be legitimate son in the eye of law. Because Muslim law of acknowledgement of paternity does not allow acknowledgement of legitimation. It only provides for declaration of legitimacy and does not allow legitimation of an illegitimate child. Therefore, the fact that son was got admitted in the school by Muslim husband as his father and brought up the son as father of such son does not confer legitimacy to such son when he is an illegitimate son. Therefore, action brought by brother of deceased Muslim husband will succeed. Facts of this case are identical to case Rashid Ahmad vs Anisa Khatun. Air 1932 PC 25, wherein their lordships observed, according to Hanafi law of Sunnis, husband could not marry with his wife after the pronouncement of talaq unless another marriage of such wife had intervened. It was therefore held that fact of subsequent treatment of divorced wife as wife and birth of child during subsequent period cannot undo the divorce and make the child legitimate. Thus, child born after the triple divorce was held to be illegitimate. Q. 34. Under what circumstances a Muslim wife is entitled to decree of dissolution of her marriage under the Dissolution of Muslim Marriage Act, 1939, which is effect of apostasy from Islam? Ans. Grounds of dissolution of Muslim marriage. Section 2 of Dissolution of Muslim Marriage Act, 1939 lays down 9 grounds on which a woman under Muslim law is entitled to decree of divorce. It says, a woman married under Muslim law shall be entitled to obtain decree for dissolution of her marriage on any one or more of the following grounds, namely: 1. Absence of husband, as per Section 2(I), when the whereabouts of the husband have not been known for period of 4 years. However, Section 2(I)(b) of Act says that a decree passed on this ground shall not take effect for a period 6 months from the date of such a decree, and if the husband appears either in person or through authorized agent within that period and satisfies the court that he is prepared to perform his conjugal duties, court shall set aside the decree. 2. Failure to maintain. The husband has neglected or has failed to provide for her maintenance for period of 2 years. Section 2(e). 3. Imprisonment of husband. The husband has been sentenced to imprisonment for period of 7 years or upwards. No decree shall however be passed on this ground until the sentence become final. Section 2(e)(a). 4. Failure to perform mortal obligation. The husband has failed to perform, without any reasonable cause, his marital obligations for a period of 3 years. Section 2(iv). 5. Impotency of husband. The husband was impotent at the time of the marriage and continues to be so, but on an application by the husband, the court shall make an order requiring the husband to satisfy the court, within 1 year from the date of such order, that he has ceased to be impotent. And if the husband so satisfies the court within such period, no decree shall be passed on this ground. Section 2(iv)(c). 6. Insanity, leprosy or venereal disease. The husband has been insane for 2 years or is suffering from leprosy, or a virulent disease. Section 2(v). 7. Reproduction of marriage by wife. She, the wife, having been given in marriage by her father or other guardian before she attained the age of 16 years, repudiated the marriage before attaining the age of 18 years, provided the marriage has not been consummated. Section 2(v)(8). Cruelty of husband. The husband treats her with cruelty, that is to say, habitually assaults her or makes her life miserable by cruelty of conduct, even if such conduct does not amount to physical ill-treatment, or b. associates with women of evil repute or leads an infamous life, or c. attempts to force her lead an immoral life, or d. disposes of her property or prevents her from exercising her legal rights over it, or a. obstructs her in the observance of her religious profession or practice, or f. if he has more wives than one, does not treat her equitably in accordance with the injunctions of the Quran. Section 2(v)(9). On any other ground which is recognized as valid for the dissolution of marriages under Muslim law. Section 2(x). This clause covers the divorces illa, zihar, Khubah, Mubarat and Tafweez. Imputation of unchastity or a false charge of adultery against the wife makes a good ground for the dissolution of her marriage. This ground falls in Clause X of Section 2 of the Dissolution of Muslim Marriage Act 1939. Effect of apostasy from Islam on marriage. Section 4 of the Dissolution of Muslim Marriage Act mentions about the effect of apostasy from Islam on marriage. The renunciation of Islam by a married Muslim woman or her conversion to a faith other than Islam shall not by itself operate to dissolve her marriage. But after such renunciation or conversion, the woman shall be entitled to obtain a decree for dissolution of her marriage on any of the above-mentioned grounds. Although apostasy of a Muslim woman shall not, by itself, be a ground for dissolution of her marriage, the conversion of a woman converted to Islam from some other faith to her former faith shall, by itself, operate as automatic dissolution of her marriage. Q. 35. The husband is not providing maintenance to his wife because of her refusal to live with him. State whether the wife can claim decree of dissolution of marriage under Dissolution of Muslim Marriage Act, 1939. Refer to decided cases. Ans. Section 2 of Dissolution of Muslim Marriage Act 1939 provides grounds for decree of dissolution of marriage. Clause E of Section 2 of the Act lays down that a woman married under Muslim law shall be entitled to obtain decree for dissolution of her marriage on the ground that the husband has neglected her, has failed to provide for her maintenance for period of 2 years. Clause IV also says where husband has failed to perform without reasonable cause his marital obligations for period of 3 years. So where the husband has neglected or has failed to provide his wife with maintenance for the period of 2 years, wife is entitled to decree of dissolution of marriage. Section 2(e) contemplates an unbroken period of 2 years next before the suit. It is to be noted that divorce can be granted on grounds which do not necessarily involve any deliberate default on the part of the husband. It is absolutely immaterial whether the failure to maintain is due to poverty, failing health, loss of work, imprisonment or any other cause. Manak Khan vs. Mulkhan Bano, Air 1941 La. 167. However, in Mahia Khatun vs. Sheikh Answer, Air 1971 Cal. 218, it was held that where the wife voluntarily stayed away from her husband's house and despite the husband's request to return to his house and live with him and despite also his offer maintaining her there, she chose to stay in the house of her relation, it cannot be said that these circumstances indicate neglect or failure on the part of husband to maintain. So legal position is clear that wife is entitled to decree of dissolution of marriage U.S. 2, IV, of the Act. If husband has neglected or failed to provide for her maintenance for period of continuous 2 years, wife is still entitled to this relief even when husband fails to maintain, not because of his own failure or incapacity but because of other reasons and beyond his control. However, where wife deliberately deserts the husband, and husband is prepared to maintain her provided she live with him. Q. 36. What are the legal effect of a divorce? Also describe the rights and obligations of the parties on divorce. Ans. The following are the legal effects of a divorce. I. Right to contract another marriage. If the marriage was not consummated, the wife is not bound to observe iddat, and she may marry again immediately. But if the marriage consummated, then the wife is bound to observe iddat, which is 3 menstrual periods. If she is not subject to menstruation, then 3 lunar months. If the wife is pregnant at the date of divorce, the period of iddat is until delivery, or 3 months, whichever is longer. Maintenance. During the period of iddat, the husband is not bound to maintain the wife. If the divorce is not communicated, the wife is entitled to maintenance even after the expiry of that period until she is informed of the divorce. Dower. If the marriage was consummated, the wife is entitled to the whole of the unpaid dower, whether prompt or deferred. But if the marriage is not consummated, the wife is entitled to half of the specified dower. Prompt dower becomes payable immediately and deferred dower also becomes due. Right of inheritance. When the divorce becomes irrevocable, mutual rights of inheritance between husband and wife cease to exist. There is one exception to this, viz. In case of a divorce given during death, illness, mar's-ul maut, in which case, the wife's right to inherit continues, till the period of iddat is over. Remarriage with divorced wife. After iddat, the parties can remarry each other, except when divorce is given by triple pronouncement of talaq. In that case, before they can remarry, the wife must be married to another person in the interval and divorced by him. Rights and obligations of parties. Until the divorce becomes irrevocable, a. The husband can revoke, and b. Either party is entitled to inherit the order. But as soon as the divorce becomes irrevocable, the wife may marry another husband, a. Immediately, if the marriage was not consummated, b. After the completion of iddat. If the marriage was consummated, where husband has 4 wives including the divorced wife at the date of the divorce, he can marry another wife immediately if his marriage with the divorced wife was not consummated and after the completion of period of iddat, where the marriage was consummated. Wife is entitled to maintenance during iddat or until she is informed of divorce. In Rashid Ahmad vs. Anisa Khatun, 1932, Bohm, L.R. 475, it was observed that sexual intercourse with divorced wife is unlawful and the issues of such an intercourse are illegitimate. That paternity cannot be acknowledged. Mutual rights of inheritance ceases after expiry of period of iddat. Wife's right of inheritance continues only if I. Divorce was pronounced during husband's death, illness and e. It was not repudiated at her own request, until expiry of the iddat. Wife become entitled to whole of the dower if the marriage was consummated and half of specified dower if marriage is not consummated. Q. 37. The law of adoption is unknown to Muslim law. In this connection, explain the meaning of acknowledgement of paternity under Muslim law. Ans. Muslim law does not recognize the institution of adoption which is recognized by other systems. On the other hand, Muslim law recognize the institution of "ikrar" or acknowledgement. Acknowledgement is not legitimation. In Muslim law, an acknowledgement of legitimacy is a declaration of legitimacy and not legitimation. The Muslim law of acknowledgement of parentage with legitimating effect has no reference whatsoever to cases in which illegitimacy of a child is proved or established either by reason of a lawful union between the parents of child being impossible or by reason of marriage necessary to render the child legitimate being disproved. The doctrine of acknowledgement applies only to cases of uncertainty as to legitimacy, but the effect of acknowledgement always proceeds upon assumption of a lawful marriage between parents of acknowledged child. In Muhammad Khan vs. Ali Khan, Air 1981 Mad. 209 Madras High Court observed that the doctrine of acknowledgement could be invoked only where the factum of marriage or exact time of the marriage could not be proved, and not to cases where a lawful union between parents of child was not possible or an adulterous connection, and where the marriage necessary to render the child legitimate was disproved. Hence a man expressly or impliedly acknowledges another as his lawful child. The paternity of the child will be established in the man, provided following conditions are fulfilled. A. The acknowledgement must not be merely of sonship but a legitimate sonship. B. The age of parties must be such that it is possible that they may be father and son. C. The child so acknowledged must not be known to be child of another. D. The child, if adult, must confirm acknowledgement. A. It is essential to show that a lawful marriage is possible between the acknowledged and child's mother, and the child is not the fruit of adulterous intercourse. F. The acknowledgement must be with distinct intention of conferring the status of legitimacy. In Muhammad, Allahabad Khan vs. Muhammad, Ismail, ILR 1887, 10.289 father of Allahabad Khan died leaving behind 2 sons and 3 daughters. Eldest son Allahabad Khan filed suit against younger brothers and 3 sisters that he was eldest son of deceased and therefore entitled to 2/7 of share in estate. Defense was that plaintiff was only stepson of father, having been born of their mother before she married with their father, deceased. Plaintiff contended that even if he failed to prove that he was son of deceased, but he had been acknowledged as such by deceased on several occasions and therefore entitled to succeed as his son. He filed certain letters in which he had been referred to by deceased as a son. Justice Mahmood held that acknowledgement under Muslim law is a rule of substantive law and not a rule of evidence. It confers status of sonship and right to succeed. Such acknowledgement always proceeds on the assumption of valid union between the parents of acknowledged son. Q. 38. What are the rules for presumption of legitimacy under Mohammedan law? Is legitimacy contrary to any provision of Indian Evidence Act 1872? Ans. Presumption of legitimacy. The following are the rules for presumption of legitimacy according to Muslim law. 1. A child born within 6 months of the marriage is illegitimate unless the father acknowledges him. 2. A child born after 6 months of the marriage is legitimate unless the father disclaims him. 3. A child born after the termination of marriage is legitimate if such child born, according to Hanafi law, within 2 lunar years, according to Shafi'i and Maliki law, within 4 lunar years, according to Shia law, within 10 lunar months. The reasons of divergent periods. The main reasons of such divergent periods are as follows. 1. In olden days 3 was imperfect knowledge of gestation and pregnancy. 2. If a woman gives birth to an illegitimate child, such child is excluded from inheritance and the mother of such child was punished for the offense of zina, illicit intercourse. 3. As per Amir Ali, the ancient jurists were actuated by sentiments of humanity and not any indifference to the laws of nature, their chief desire being to prevent the abuse of the provisions of law regarding divorce and the disavowal of children. The presumption of marriage does not arise from a long cohabitation if the woman was a prostitute and even if she was brought to home of a person as his wife. Conflict with the provisions of Section 112 of Indian Evidence Act with Muslim law. According to Section 112 of the Indian Evidence Act 1872, a child born during the continuance of a valid marriage, or within 280 days after its dissolution, the mother remaining unmarried, is the conclusive presumption of legitimacy, unless there was no access when he, the child, could have been begotten. Conflict between those two set of rules. Muslim law. Section 112 of Indian Evidence Act. 1. A child is illegitimate if born within less than 6 months after marriage unless the father acknowledges it. 1. A child born even a day after marriage is legitimate unless parents had no access to each other at any time during he which could have been begotten. 2. A child born after 6 months from the date of marriage is presumed to be legitimate unless putative father disclaims the child by li'an. 2. A child is legitimate under either system, subject to li'an in one case and proof of non-access with other, even if the child is born after 6 months from the date of marriage and within 280 days of termination of marriage. 3. The child is presumed to be legitimate if born within 2 years after the termination of marriage unless such legitimacy is disproved by laying. 3. A child is legitimate according to Hanafi law if born between 280 days and 2 years after the termination of marriage. Q. 39. What are the various kinds of guardianship according to Muslim law? Describe in brief about each. Ans. Guardianship. One of the remarkable features of Muslim law is that the rules for the guardianship of a minor, a. of his person, b. property and c. with guardianship, have been well defined. The guardianship and custody of the minors are two different things and the same have been recognized in the verses of Quran as well as in Hadith. Raddul Mukhtar also recognized the right of a father and, in his absence, of an executive, of the guardianship over the person and properties of his minor. In the same way, Father Alamgiri also recognized the same thing in these words. The executor of a father is in the place of father and also the executor of grandfather is in the place of grandfather and the executor of the grandfather's executor is in the place of pay. Grandfather's executor and the executor of the judge is in the place of a judge when his appointment is in general. Appointment of guardian, a Muslim, other than father, can become a guardian of a minor even without the previous orders of the court. There is nothing to prevent him from applying in the court under the Guardians and Wards Act, for declaration as guardian under this act. The fact is that any person desirous of being or claiming to be the guardian of a minor and any relative or a friend of minor can apply, on the form prescribed under Section 10 of the Act, to a court. The orders for the appointment of guardian should, however, not be made by the court without giving proper notice of application to all such persons interested in the minor. Kinds of guardianship. Guardians, according to Muslim law, are divided into the following categories. 1. Natural guardian. 2. Testamentary guardian. 3. Guardian appointed by court. 1. Natural guardian. Muslim law-givers have not used the term of natural guardian in Muslim law, but all schools of Sunnis and Shia school recognize the father of a minor as legal guardian. In other words, it is recognition of natural guardianship. However, mother is not recognized as natural guardian even after the death of the father of a minor. A mother or any other female member is not entitled to the custody of a minor, as was decided in Imambadi vs. Mutsadi, 1918-45, Cal. 887. He, father, is the sole and supreme guardian of his minor children. He has also a right to control and upbringing and the movement of his minor children. A father neither has a right of guardianship nor the custody of illegitimate children. According to Sunni school, a Muslim father is the only guardian of the minor children, and after his death, it is passed on to his legal executors. According to Shia schools, the guardianship of a minor passes on to the grandfather after the death of father. It appears that Shias do not recognize the natural guardianship of anybody, even of the brother, except father and grandfather. So far as the position of a Muslim woman about guardianship is concerned, she can have the custody of a minor only for the period prescribed in Muslim law. 2. Testamentary guardian. It is a rule in Sunnis that a father of a minor can make a testamentary appointment of a guardian, and in his absence his executor or the grandfather can do so. In Shias, a father can make appointment of a testamentary guardian only when grandfather is absent. No other person has any power of making an appointment of a testamentary guardian of her illegitimate children. Mother can, however, appoint a testamentary guardian in following two cases. A. When child's father has appointed her as executor by his will. B. When she wishes to appoint an executor in respect of her own property, which will devolve after her death, on her children. In these cases, a mother can appoint a testamentary guardian of the property of her minor children, legitimate or illegitimate. A non-Muslim mother can also be appointed as valid guardian according to Sunnis, but among Shias it is not valid. Shias believe that a non-Muslim woman cannot be a guardian of a person as well as property of a minor. A non-Muslim alien also cannot be appointed as testamentary guardian, and if such appointment is made, it will be null or void. Another characteristic of the testamentary guardianship is that a person who bears a notoriously bad character in the public walk of the life, i.e. profligate, cannot be appointed as guardian. In the case such person is appointed as guardian by mistake, all acts done prior to his removal will be deemed valid, provided that they may not be contrary to the interest of minor. Appointment of testamentary guardian. A testamentary guardian may be appointed orally or in writing. Muslim law does not prescribe any specific formalities for the same. As per Fatwa Al-Mgiri, it is necessary that in each case, the intention to appoint a testamentary guardian must be clear and unequivocal. The testamentary disposition made by a testator may be valid, but appointment of the testamentary guardian of the minor may be invalid. The testator must have the capacity to make the will at the time when it was executed, i.e., he should be major and of sound mind. When an executor is appointed by a testator, it is the duty of the executor to administer the estate and assets of the testator, to carry out the wishes of testator with utmost fidelity and c. to act as guardian of minor. It is necessary that the appointment of testamentary guardianship must be accepted. Such acceptance can either be express or implied. Such guardianship, if once accepted, cannot be renounced, save with the permission of the court. 3. Guardian appointed by court. Under the Guardian and Wards Act, 1890, a district judge may appoint a guardian of a minor child's person and property, whenever it is considered necessary by him for the welfare of the minor. While making such appointment, the district judge will take into consideration the age, sex, wishes of the child as well as the wishes of the parents and the personal law of minor. Prior to the enforcement of this act, a qazi was entrusted with the power to appoint a guardian of a Muslim minor when the natural guardian or testamentary guardian had failed. Now the powers of qazi have been abrogated after passing of this act. Q. 40 Who are the guardian of a Muslim minor under Mohammedan law? Ans. The term guardianship, vilayat, connotes the guardianship of minor. A minor is one who has not attained the age of majority. Puberty and majority are one and same under the Muslim law. Puberty is presumed to have been attained on the completion of 15th year. A minor cannot manage his or her estate, education, career etc. As such, a guardian is required in order to look after his or her welfare till such minor attains the age of puberty. Under Mohammedan law, the mother is entitled to the custody, hizana, of minor's person. The mother is entitled in Sunni law to the custody of her male child until his age of 7 years, and in case of female child until she attain puberty. In Shia law, mother is entitled to custody of her male child till the age of 2 years, and in case of female child up to 7 years of her age. This right of mother shall continue even if she is divorced by the father of child, and will continue until she marries a second husband, and in that eventuality the custody belongs to father of child. In Imambadi vs. Mustadi, 1918-45 IA 73, Privy Council had observed, under Mohammedan law the mother is entitled only to the custody of person of her minor child up to certain age. She is the de facto guardian and she is not natural guardian of minor child. Under Sunni law, failing the mother, custody of boy under the age of 7 years and of girl who has not attained puberty goes to A. Mother's mother or B. Father's mother, C. Full sister or D. Uterine sister, A. Consanguine sister or F. Full sister's daughter, G. Uterine sister's daughter or H. Consanguine sister's daughter or maternal or paternal aunt, mother or other female relation, as stated above, will lose right to hizana if I. If she leads a moral life or E. She neglects to take proper care of child or E. If she marries to a person not related to child within prohibited degree. IV. If she goes and resides at distance place. In default of mother or other female relations, hizana, under Sunni law belongs to I. Father or E. Paternal grandfather or E. Full brother or IV. Consanguine brother or V. Full brother's son or V. Consanguine brother's son or V. Full brother of father etc. However, male relation as stated above will not be entitled to custody of an unmarried girl unless he stands in prohibited degree relationship with such girl. If there be none of the above said guardian of a minor, then court shall appoint guardian of such child. Under Shia law, failing mother, the father, and failing father, paternal father of minor child is entitled to hizana of minor child. In Sunni law, custody of a boy over the age of 7 years and of an unmarried girl who has attained puberty shall be with the father, and in Shia law, father is entitled to custody of male child over the age of 2 years and female child over the age of 7 years. Q. 41. Who is entitled to guardianship of a Muslim wife who has not attained the age of puberty? Ans. Under Muslim law, the mother of a girl who is married but has not attained puberty is entitled to the custody of the girl as against the husband of the girl. The court has no power under the Guardian and Wards Act to appoint a guardian of the person of a minor. Where the minor is a married woman and her husband is not, in the opinion of court, unfit to be guardians of her person. If it be a rule of Mohammedan law that a husband is not entitled to the custody of his wife until he has attained puberty, it must be taken to rest on the hypothesis that he is unfit by that law for that custody. If so, the court may hold U.S. 19 of Guardian and Wards Act that a Mohammedan husband is unfit, within the meaning of that section, to be guardian of the person of his wife until she has attained puberty, and may consistently with the provision of that section appoint her mother as her guardian until she attains puberty. Q. 42. Describe the powers of a guardian on the property of a minor. Ans. The power of a guardian on the property of a minor are as follows. 1. Powers on the immovable property. 2. Powers on the movable property. 3. Powers to purchase and sell the property. 1. Powers on the immovable property. The powers on the immovable property of a minor are exercised by a guardian according to his own capacity. For example, a legal guardian have more powers in this regard than the guardian appointed by court or a de facto guardian. A. The powers of a legal guardian. A legal guardian normally cannot sell the immovable property of a minor. He can, however, do so, 1. When he can obtain its double value, or 2. when it becomes necessary for the maintenance of the minor. 3. When there are debts and legacies for which there is no other means for their payment, or 4. When the property is likely to fall or destroy. b. The powers of a de facto guardian. A de facto guardian cannot sell the property of a minor. Even then, if he does so, such sale will be of nullity. He, de facto guardian, can also refer the dispute, if any, relating to the property, to arbitration. In this connection, in the case of Johra Bibi vs. Muhammad Sadak, Air 1951, Mad 992, it was held that even the mother of a minor, without getting herself appointed as a legal guardian, cannot refer the matter to arbitration. Even the sale deed executed by a mother as a de facto guardian on the property of her minor is held void and inoperative, as already decided in the case of Venkama Naidu vs. Chisti, Air 1951 Mad. 399. 2. Powers on movable property of minor. A legal guardian can sell or charge the movable property for the minor's bare necessities like food, clothing and nursing. A de facto guardian can also exercise the same power. The guardian appointed by court can deal with the property of minor as carefully as would a man of ordinary prudence, if it were his own. In brief, he has more powers in this regard than the guardians of other two categories. 3. Power to purchase a movable property. The guardian of a minor has no right to enter into an agreement for the purchase of a movable property on behalf of the minor. It was held in the case of Mir Sarvarajan vs. Fakhruddin, 1912, 39, IA, that, if he does so, such an agreement will be void. Sometimes, a question arises whether an agreement, entered into by a minor through his guardian for the purchase of a property, has any legal force and recognition for the specific performance of such agreement. This problem was resolved in Amir Ahmed vs. Mir Ali Air 1959 HYD 120, when it was held, if the agreement is entered into by a minor through a person other than de jure guardian, the reply will be negative. If it is done through de jure guardian, the reply is yes. Q. 43. Discuss the law regarding custody of minor under Muslim law. Ans. Hizana. This term means the custody. Under Sunni law, mother is entitled to custody, hizana, of her male child until he has completed the age of 7 years, and in case of female child unless she has attained puberty. Under Shia law, mother is entitled to custody of male child till the age of 2 years and for her female child till the age of 7 years. Mother's right of hizana continues though she is divorced by the father of the child unless she marries a second husband, in which case the custody belongs to the father. Under Sunni law, failing the mother, hizana, custody, of a boy under the age of 7 years and girl who has not attained puberty goes to following female relatives: a. Mother's mother, b. Father's mother, c. Full sister, d. Uterine sister, a. Consanguine sister, f. Full sister's daughter, g. Uterine sister's daughter. However, right of hizana of mother or any female relative is lost if I. She lead an immoral life, or e. If she marries a person not related to the child within prohibited degree, if during the subsistence of marriage she goes and resides at a distance from the father's place. In case of absence of mother or female relatives, the right of hizana under Sunni law belongs to I. Father, nearest paternal grandfather, full brother, IV, consanguine brother, V, full brother's son, V, consanguine brother's son etc. Provided, no male is entitled to custody of unmarried girl unless he stands within prohibited degree of relationship to her, and if there is none of the above guardian, it is for court to appoint guardian of the person of a minor. Under Shia law, failing mother, the father, and failing the father's father is entitled to the custody of minor's person. In case of boy over the age 7 years and unmarried girl who has attained puberty, father is entitled under Sunni law to the custody, and under Shia law, father is entitled to hizana of male child above 2 years and unmarried girl of 7 years or more. Q. 44 Define gift. What are the essentials of a valid gift? Ans. In Muslim law gift is called hiba, which is a well-defined legal concept. The term hiba, according to Mullah, is a hiba or a gift is transfer of property made immediately and without any exchange by one person to another and accepted by or on behalf of latter. Section 122 of Transfer of Property Act 1882 says, a gift is transfer of certain existing movable or immovable property made voluntarily and without any consideration by one person called donor, to another called the donee, and accepted by or on behalf of the donee. In Abdul Manan vs. M.D. Murad Ali and others. 1999 Family Law Cases 108 Patna High Court lays down following essentials for validity of gift. A. Declaration of gift by donor. B. Acceptance of gift by donee. C. Delivery of possession of property gifted by donor to donee. So from above discussion, it is clear that following are essentials of gift. I. Parties. E. Subject matter. E. Transfer. IV. Acceptance. V. Absence of consideration. V. Voluntarily. 1. Parties. There are two parties to a gift. One who donates a thing or property is called donor, and other who accepts it is called donee. Every person who is competent to transfer the property under Section 7 of Transfer of Property Act can validly make a gift. The minors cannot do so. The donation should be for a specific person or for a group of persons or for an institution etc. The donation made for public at large and without any definite object is not valid. A gift by a married woman is valid and subject to same legal consequences. A gift by a pardanasheen lady is valid. But in case of a dispute, the burden of proving that it was not induced by undue influence and the donor understood the nature of the transaction while making it, lies on the donee. 2. Subject matter. The subject matter of the gift must be movable or immovable property which is actually in existence at the time of making gift. The future goods or property cannot be donated or given as gift. 3. Transfer. The ownership of a thing or property is transferred to donee from donor no sooner it is donated. If the subject matter of donation is a movable property, its transfer will take place through registered documents and by giving physical possession. 4. Acceptance. The gift must be accepted by the donee or by someone duly authorized by him. The donation without the acceptance of donee is not held valid. The consent of donee must also be given during the lifetime of donor. 5. Absence of consideration. Donation is such a transfer with obligation in which consideration has no place. The term consideration has the same meaning as has been given in Indian Contract Act and does not include natural love and affection. The gift made due to some spiritual or moral basis or due to natural love and affection is always held valid in law. If any condition is imposed with gift, the gift will be valid and the conditions so imposed will be invalid. 6. Voluntarily. The gift must be made voluntarily. The term voluntarily does not mean unfettered "free will" of a person. When a person has some property of his own and donates it to other person or persons without any pressure or influence for a specific object, without any consideration and with his free will, the gift so made by him will be held legally valid. If the donor is "Pardhanashan woman, her total acts and conducts must be taken into consideration for assuming that she had a full opportunity to express her "free will" for the gift. Q. 45c. A Muslim executed a deed of gift of a house in favor of D. At the time of gift the house was in possession of A who claimed it adversely to CD sues A to recover possession of the house as donee of the property and joins C also as defendant. C in his written statement admits claim of D. A contends that the gift is void since C had no possession of the house at the date of the gift and no possession was ever given to D. Decide. Ans. Gift or "hiba" under Muslim law means transfer of property made immediately without any consideration. During the lifetime a Mohammedan can make gift of all or any part of his property. Word "hiba" literally means the donation of a thing from which donee may derive benefits. Every Muslim of sound mind and who has attained majority can make gift. However, under Muslim law, for the validity of gift following essential conditions must be fulfilled. A. There must be clear, unambiguous and specific declaration of gift by donor to donee. B. There must be acceptance of gift expressly or impliedly by or on behalf of donee. C. That there must be delivery of possession of subject of the gift by donor to donee. Section 149 of the Mullah's Principles of Mohammedan Law also provide. It is essential to the validity of a gift that there should be 1. A declaration of gift by the donor. 2. Acceptance of the gift express or implied by or on behalf of donee. 3. Delivery of possession of the subject of the gift by donor to donee in accordance with the provisions of Section 150. If these conditions are complied with, the gift is complete, and if any of 3 conditions mentioned above is not satisfied, there cannot be a valid gift. In Abdul Manan vs. MD. Murad Ali and others, 1999 Family Law Cases 108 Patna High Court also discussed the essentials of a valid gift and provided following essentials for validity of gift: a. Declaration of gift by donor. b. Acceptance of gift by donee. c. Delivery of possession of property gifted by donor to donee. Thus it is clear that above state conditions must be fulfilled for the validity of a gift. Delivery possession of subject to be gifted must be effected from donor to donee. Where the subject matter of gift is in the possession of a person holding the property adversely to the donor, the gift is not valid unless donor either recovers possession or does all that he can, which is necessary to put the donee in possession. In Maqbool Alam vs. MST. Khodaija, Air 1966 South Carolina 1194, Supreme Court held that if the gifted property is in wrongful possession of a trespasser, a mere declaration and acceptance of gift would not make it complete. There must be either delivery of possession or some overt act by the donor to put it in the power of the donee to obtain possession. Coming now to case in hand, donor C has done all that he can do to complete the gift. He is party to the suit filed by donee, D, and admits the claim of donee in fact of gift. Therefore C by admitting the gift to D has made D to obtain possession from A, and thus C has given constructive possession of property gifted to D, and therefore gift of C to D is valid. Q. 46. A gift of a house was made by donor X to donee Y without delivering the title deed. No mutation of name was affected and the donor continued to pay the house tax. Comment whether gift is valid. Ans. For the validity of gift or hiba under Muslim law, it is essential that a. Donor must make declaration of gift. b. Donee must expressly or impliedly accept the gift made by donor. c. Donor must make delivery of possession property gifted to donee. So donor should divert himself completely of all ownership and dominion over the subject of the gift. For completing the gift of a movable property, two things are essential. A. That donor must physically depart from a movable property. b. Donee formally and actually enters into the possession of such property. In the case in hand, there is nothing to show that possession of house was delivered by donor to donee, nor the title deed was delivered to donee. The mutation has also not been effected in favor the donee in revenue and municipal record, and donor is still paying house tax. Thus in records, house still stands in the name of donor. There is no actual and formal delivery of possession from donor to donee, therefore gift is incomplete, hence not valid. Q. 47. Explain the gift of mushaa. Ans. A musha is an Arabic word meaning undivided, share in a property. The rule as to musha, as laid down in headya, is gift of a part of a thing which is capable of division is not valid unless the said part is divided off and separated from the property of the donor. A gift of an indivisible thing is valid. There is no unanimity of opinion among different schools of Muslim law on question of the validity of the doctrine of musha. According to Shia school, a gift of undivided property can validity be made provided donor must give to donee the possession of undivided property. On the other hand, Hanafi school does not recognize the doctrine of Musha. In Asha Shaukat and others vs. State of Bihar and others, 1997 Family Law Cases, HC 282 Patna High Court held doctrine of Musha. If the subject matter of gift is divisible, then an undivided part cannot form the subject of gift, on the principle of Musha. But if it cannot be divisible, the undivided part can form the part of the subject matter of gift on these principles. Kinds of Musha. A Musha may be either 1. In a property incapable of division, or 2. In property capable of division. 1. Musha in a property incapable of division. A gift of an undivided share in property, Musha, which is not capable of division is valid. In Qasem Hussain vs. Sharif Unnissa, 1833-5 all. 385. A who owns a house makes a gift to be of the house and of right to use staircase by him jointly with the owner of adjoining house. Gift of A is undivided share in staircase, though it is a gift of Musha, is valid as staircase is not capable of division. 2. Musha in property capable of division. Property is capable of division. Gift of Musha will be irregular though not void under Hanafi law. It means it can be rendered valid by subsequent partition and delivery. Exceptions to the general rule. The following are the exceptions to the general rule regarding gift of the Musha. 1. If the gift is made by one co-sharer to the other, the doctrine of Musha will not apply. In the case of MD. Book vs. Hossainil 1889-15, I.A. 81 A Muslim died leaving his widow W, son S, and a daughter D. After getting succession to the property of deceased, widow W made a gift of her undivided share in the inherited property to S and D. The gift was held valid by the court. In such case only so much is necessary that the donor should divest himself or herself totally of his or her proprietary rights. 2. The gift of a share in zamindari or a taluka can be made. In the case of Ismail vs. Idris, it was held that the gift of an undivided share in Karmi land is valid. 3. If the gift of a share in freehold property in a large town is made. In the case of Ghulam Arif vs. Saido, it was held that the gift of 1/3 of the house owned by donor was valid. 4. When the gift is a share in the landed property. In Ibrahim vs. Saido, it was held it would be proper to apply this doctrine, i.e. doctrine of Musha, to shares to very different categories of property. Q. 48 Define Hiba bil Iwaz and Hiba by Sharti ul Iwaz. What is the difference in between these two? Ans. Hiba bil Iwaz. Hiba bil Iwaz is a gift for a consideration. It has almost all the incidents of a contract of sale. Hiba bil Iwaz has, as per Asaf A. Faizi, has two separate parts, i.e. A. Hiba, original gift by the donor to the donee, and B. An Iwaz, return gift by the donee to the donor. In short, the Hiba bil Iwaz means a gift with return. Therefore, when both things, i.e. Hiba, gift, and Iwaz, return, is completed, the transaction is called hiba bil iwas. For example, A makes a gift of a cow to B, and later B makes a gift of a horse to A. If B says that the horse was given to him by A, by way of return or exchange, then both are irrevocable. The law requires the completion of all the formalities of a valid hiba in such transaction. In the case of Rohini Bukhash vs. Muhammad Hassan 1888-11 all. 15. It was held by the court that the fundamental conception of hiba bil iwas in Mohammedan law is that is a transaction made of two separate acts of the donation, i.e. it is a transaction made up of mutual or reciprocal gift between two persons, each of whom is alternatively the donor of one gifts and the donee of the other. The matter was described by Bailey in these words, the transaction which goes by the name of hiba bil iwas in India is therefore in reality not a proper hiba bil iwas of either kind but a sale and has all incidents of the latter contract. There are two conditions for a valid hiba bil iwas. 1. Actual payment of consideration, iwas, on the part of donee, and 2. A bona fide intention on the part of the donor to divest himself in present of the property and to confer it upon donee. A and B, two Muslim brothers, are tenants in common. A died leaving B and his widow W. After his death B executed a deed whereby he granted two of the villages to W, and W executed a writing whereby in consideration of the grant to her, she gave up her claim to her husband's estate in favor of B. The transaction was hiba bil iwas and was valid though possession was not delivered. Muhammad Faz Ahmad Khan vs. Ghulam Ahmad Khan 3 all 494. Therefore, the absence of consideration is not necessary in such hiba, but the amount, whatever it is, must be actually and bona fidely paid. Hiba ba shart ul iwas, when a gift, hiba, is made by someone with a stipulation, shart, for return, iwas, such transaction is called hiba ba shart ul iwas, Amir Ali. In hiba ba shart ul iwas, a gift is not followed by a voluntary return but it is made with stipulation. Tayyibji said that in such hiba the two, gift and return, go hand in hand, not one before the other, and the return is in completion by both parties. He said that kind of property that can also be given by way of return gift, iwas, and the return gift must be made with all the formalities necessary for a hiba. Once hiba ba shart ul iwas is completed by delivery of possession, neither of the party to it can, afterwards, revoke it. For example, A made gift of his house to B, and put him in possession. B then gives A horse in an iwas and A accepted it. After some time A purports to sell the house to someone. Such sale will not be effective because gift with condition of return, once completed, cannot be revoked in any circumstances. Hiba ba shart iwas is also subject to the right of preemption. Difference between these two hibas. There are following differences between them. Hiba bil iwas. Hiba ba Shat ul Iwas. 1. In such hiba the Iwas, return, is not even in the contemplation of the parties at the time of original gift. 1. In such hiba, lawaz, return, is not merely in contemplation of the parties but it is expressly stipulated for. 2. It bears the character of gift throughout and does not partake the character of sale even when hiba is given. 2. It bears the character of sale because the item can be returned if it is defective. 3. In such hiba, no sooner the possession of subject matter of hiba is given to doni is iwas, then it becomes a sale. 3. It is not so. 4. Delivery of possession of subject matter of gift is not necessary. 4. Delivery of possession is necessary. 5. There is not such condition. 5. It can be revoked at any time before the delivery of possession and if it is completed, a hiba cannot be revoked. Q. 49. Explain the doctrine of Marzulmaut, death, illness, gift under Muslim law. Ans. Gift or hiba literally means donation of a thing from which doni may derive a benefit. It is the conferring of property without consideration. During the lifetime of a Mohammedan he can make gift of all or any part of his property but his right to do so by way of will or while on the deathbed is subject to some restrictions. Deathbed illness, Marzulmaut, when a person is suffering from (mars) illness, and is under the apprehension of his (maut) death, he is said to be suffering from (mazumat). In Safia Begum vs. Abdul Riyaz, Air 1945 Bohm. 538, it was held that crucial test of (mazumat) is the subjective apprehension of death in the mind of the donor, i.e. apprehension derived from his own consciousness is distinguished from the apprehension caused in the mind by others of other symptoms or physical incapacities are only indications but infallible signs of (mazumat). Essentials of deathbed gift. A gift that is made during death illness is called a deathbed gift and it's subject to certain restrictions. Deathbed illness gift transaction essentially and basically being gift must satisfy all the formalities that are essential for making gift, which are a. Declaration of gift by donor, b. Acceptance of gift, and c. Delivery of subject matter of gift from donor to doni. It is important to point out that deathbed gift is operative as such after the donor's death. In Mumtaz Ahmad vs. Vasionessa, Air 1948 Odd. 301. It was held that doctrine of Mazumo applies to cases where the gift is made under pressure of sense of imminence of death. Though a Muslim has unlimited power to dispose of his property by way of gift, but donor's power to dispose of his property by gift during death illness is subject to following restriction. I. Gift to non-heir. He cannot make gift of more than 1/3 of his property in favor of non-heir unless the other heirs give consent to the excess taking effect. E. Gift to an heir. The gift to an heir made during death illness is altogether invalid unless the other heirs consent to it. E. A gift made during death illness is subject to all conditions and formalities necessary to constitute a gift inter vivos, so there must be declaration. Acceptance and actual or constructive delivery of possession. Q. 50 Raymond is suffering from blood cancer and is bedridden. When he came to know it, he gave all his property in favor of his wife by way of gift. 6 months later he dies. His legal heirs challenge the gift, hiba. Will they succeed? Ans. Gift or hiba literally means donation of a thing from which donee may derive a benefit. It is the conferring of property without consideration. During the lifetime of a Mohammedan, he can make gift of all or any part of his property, but his right to do so by way of will or while on the deathbed is subject to some restrictions. Deathbed illness, marzulmaut. When a person suffering from "marries" illness, and is under the apprehension of his "maut" death, he is said to be suffering from "maut." In Safia Begum vs. Abdul Rayas, Air 1945 Bom. 538. It was held that crucial test of "maut" is the subjective apprehension of death in the mind of the donor, i.e. apprehension derived from his own consciousness is distinguished from the apprehension caused in the mind by others of other. Symptoms or physical incapacities are only indications but infallible signs of "maut." Essentials of deathbed gift. A gift that is made during death illness is called a deathbed gift and it's subject to certain restrictions. Deathbed illness gift transaction essentially and basically being gift must satisfy all the formalities that are essential for making gift, which are a. Declaration of gift by donor, b. Acceptance of gift, and c. Delivery of subject matter of gift from donor to donee. It is important to point out that deathbed gift is operative as such after the donor's death. In Mumtaz Ahmad vs. Vasionessa, Air 1948 Odd. 301. It was held that doctrine of Mazumo applies to cases where the gift is made under pressure of sense of imminence of death. Though a Muslim has unlimited power to dispose of his property by way of gift, but donor's power to dispose of his property by gift during death illness is subject to following restriction. I. Gift to non-heir. He cannot make gift a more than 1/3 of his property in favor of non-heir unless the other heir give consent to the excess taking effect. E. Gift to an heir. The gift to an heir made during death illness is altogether invalid unless the other heirs consent to it. E. A gift made during death illness is subject to all conditions and formalities necessary to constitute a gift inter vivos, so there must be declaration, acceptance and actual or constructive delivery of possession. In view of the above discussion, it is clear that deathbed gift made by Raymond in favor of his wife of all of his property is not valid and not enforceable, and therefore other legal heirs of Raymond will be entitled to the property of Raymond in accordance with succession rules under Muslim law. Q. 51. A. Can a gift once made be revoked? If so, what is the provisions for such revocation? B. What are those gifts which cannot be revoked afterwards? Ans. A. Revocation of gift. A gift once made can, with a few exceptions, be subsequently revoked. According to Tayyibji in Muslim law, all voluntary transactions are revocable, since the revocability is one of the characteristics of the law of gift. Bailey, however, said that all gifts are not revocable. The text contains a long list of gifts which cannot be revoked if once perfected by delivery. Amir Ali and others were of the opinion that gift once completed can be revoked only by the intervention of the court of law or by consent of donee. A mere declaration on the part of the donor is not enough. The revocation of gift can be studied under the following headings. A. Before delivery of possession. B. After delivery of possession. Revocation of gift before the delivery of possession. Every gift can be revoked under Muslim law, if the delivery of possession of the gift property has not been given to the donee. The reason is that under Muslim law, a gift is not complete till delivery of possession is made. Therefore, the revocation of such gift merely means that the donor has changed his mind and he does not want to complete it by the delivery of possession. The order of a court is not necessary for such revocation. Faizi in this connection said that in such cases, a gift becomes inchoate gift and it is not proper to apply the term revocation to such gifts. Revocation of gift after the delivery of possession. A gift cannot easily be revoked after the delivery of possession to donee. Once the possession of a gift property has been given to donee by a donor, such gift cannot subsequently be revoked merely by a. Declaration of revocation or b. Instituting a suit or c. By any other action. It is possible only when the decree of court is passed. Discussing the right of done in such circumstances, it was said in the case of Mehboob vs. Abdul, 1964, Raj. 250, that till a decree of the court is passed for revoking the gift, the donee is entitled to use the property in any manner. He can also alienate it. It seems that a. A gift can be revoked after delivery of possession if donee gives consent for the same, or b. Revocation can be done by decree of the court. Since the gift is given by donor, the right of its revocation confines within him only being his personal right. Heirs of a donor afterwards or at any time cannot revoke it. Difference of opinion between Shias and Sunnis about revocation. There are difference of opinions between Sunnis and Shias about revocation of a gift in following respects. Shiites recognized that 1. It cannot be revoked if it has been made by a husband to wife or by a wife to her husband. 2. A gift made to a relation, whether within prohibited degrees or not, cannot be revoked. 3. It can be revoked by a mere declaration of donor and the proceedings of the court of law are not required. However, Shafi and Maliki, Sunnis, believe that if a gift has not been made under pressure or misconception, it cannot be revoked whether the delivery of possession was given or not. b. Irrevocable gifts. As per Asaf A. Faizi, the following gifts cannot be revoked. 1. When a gift is made to a person who is so closely related by consanguinity that if the parties differed in sex, a marriage between them would be unlawful. 2. By a wife to the husband or by the husband to a wife. 3. When the donor or donee dies. 4. When the thing given is lost or destroyed. 5. When the thing given has been transferred by the donee by gift, sale or otherwise. 6. When thing has increased in value, whatever be the cause of such increase. 7. when the donor has accepted a return, iwas, for the gift. 8. Where the motive for the gift is religious or spiritual. For such a case a gift amounts to sadaqah. Q. 52. Define will. What are the essential elements of a valid will? Who can make a will? Ans. Meaning of will, wasiyat. A will is the legal declaration of the intention of a testator with respect to his property which he desires to be carried into effect after his death. Section 3 Indian Succession Act. Wills have been declared legal by Quran. From says that, it is an instrument by which a person makes a disposition of his property to take effect after his demise and which is in its own nature ambulatory and revocable during his life. Fatwa-i-Almgiri defines a will to be a conferment of a right of property in a specific thing or in gratuity, to take effect on the death of the testator. Thus, will denotes the last desire of a person for the distribution of his properties after his demise. Thus a will is constituted of two elements. I. Conferment of right in a property. E. Which is to take effect after the death of the testator. Nature. The transfer of right under a will is not an immediate disposition but is deferred till testator's death, while an immediate transfer of interest of right is essential in a gift. Conditions of a valid will. There are two conditions of a valid will. 1. There should be a distinct and express intention to give, and 2. The disposition must be intended by the testator to take effect after his death. If these two conditions are established, then no particular form is necessary for a valid will. Muslim law does not prescribe any particular formality for valid will. The only requirement is that there must be manifestation of the intention to transfer the ownership of some of his properties upon legatee without consideration. It may be oral will or in writing. The provision of Indian Succession Act do not apply to Muslims' will. Who can make a will? Subject to the limitations on the testamentary powers, every Muslim who is I. of sound mind, and e. has attained majority under the Indian Majority Act, 18 years, or if guardian has been appointed of his person or property by the court or he is under the supervision of court of wards, then 21 years, is capable of disposing of his property by will. 3. Will by a lunatic. Such a will is void ab initio and cannot be validated by ratification. Similarly, if a person of sound mind becomes permanently of unsound mind after making bequest, the bequest will become invalid. 4. Will of an apostate. The testator must be a Muslim at the time of making the will. According to Maliki school, apostasy annuls such a will, but according to the Hanafis, the will would be effective if it is lawful according to the sect from which he has apostatized. 5. Will of a person condemned to death. Such a person cannot be deprived of the power of making a will. 6. Will by insolvent. A person making a will should be solvent, if his liabilities exceed his assets. The bequest will not be effective unless the creditors discharge the estate from the payment of their debts. Q. 53. What are the limitations on testamentary powers of creating a will by a Muslim under Shia and Sunni law? In what manner can a will be revoked? Ans. Mohammedan law has not given unlimited testamentary powers to Muslim. The limitation as regards the testamentary powers of Muslim are follows. 1. There is restriction to the extent of the property. 2. There is restriction as to person to whom the bequest may be made. Limits as regards to property. A Muslim may not make a will of more than 1/3 of property what remains of his estate after payment of funeral expenses and debt, provided heirs' consent is not obtained after the death of testator. Therefore a Muslim can make a valid bequest in favor of non-heir or stranger only to the extent of 1/3 of net assets remaining after payment of funeral expenses and debts. It is however important to point out. A Muslim cannot create by will an estate repugnant to the law. B. It is not necessary that the thing should be in existence at the time of testator's death. C. A bequest may be made of anything which is capable of being transferred. Limits as regards to person. 1. Bequest in favor of an heir. The general rule in this regard is that the bequest in favor of an heir is invalid unless the other heirs consent to it after the death of the testator. A bequest to a non-Muslim, b. also valid according to all schools except that of Shafi. This general rule seems to be justifiable on the grounds that a. It prevents a testator from interfering with or defeating the rule of inheritance. B. A bequest in favor of an heir to the exclusion of other heirs would be an injury to the latter and it would reduce their shares. C. It would consequently induce a breach of the ties of kindred. Such a consent should be given after the death of the testator. Before the death of the ancestor, under Sunni law, the person gets no interest in the property. Under Shia law the consent may be before the testator's death. 2. Bequest in favor of an heir and stranger. When the bequest is made to an heir and also to a stranger, the bequest to the heir is invalid unless assented to by other heir. Bequest to the stranger is valid to the extent of 1/3 road of the property. 3. Bequest to an unborn person. A bequest to an unborn is void according to Sunni law. It is valid if it is made to a child in the womb provided it is born within 6 months of the date of the will. Under Shia law, a bequest to a child in womb is valid if it is born in the longest period of gestation, i.e., 10 months. 4. Bequest to a testator's murder. A bequest to a person who causes the death of the testator whether intentionally or accidentally, is void under Sunni law. Under Shia law, such bequest is void only when the murder was intentionally done. If it was done accidentally by him, it will not be void. Revocation of will. 1. A testator may at any time revokes his will. The revocation may be I. Expressed verbally, or e. Expressed in writing, or e. Implied, i.e., by some act which shows an intention to revoke it. Some of the instances of implied revocation are: a. A bequest of a piece of land is revoked if the testator subsequently builds a house. b. A bequest of house is revoked if the testator sells it or makes a gift of it to another. c. It is completely after the nature of property. Q. 54p. A Muslim has a son S. a wife W and a grandson G from a predeceased son DP make a will of his whole property in favor of G. Decide the validity of this bequest. Ans. The testamentary capacity of a Muslim is limited in two ways. He does not possess an unlimited power of making disposition of property by will. There are twofold power restrictions on the power of a Muslim to dispose of his property by will. First restriction is in respect of person in whose favor the bequest is made, and second restriction is as to extent to which he can dispose of his property. Limitation as regard the person. General rule is that bequest in favor of an heir even to the extent of 1/3 was not valid under Sunni law unless the other heirs consented to it, expressly or impliedly, after the death of the testator. Under Shia law, testator may without the consent of other heir give a legacy to an heir so long as it does not exceed 1/3 road of his estate. The only case in which testamentary disposition is binding upon the heirs is where the bequest does not exceed the legal third and it is made to a person who is not an heir but a bequest in excess of. Legal third may be validated by the consent of the heirs. Limitation as regard to the property. General rule with regard to the extent of property that may be disposed of by will is that no Muslim can make bequest of more than 1/3 road of his net assets after payment of funeral charges and debt. In case in hand the grandson is not an heir. Therefore, the bequest to him is valid to the extent of 1/3 road without the consent of son and the wife. 55 Mahmud has got property worth 10 lakh rupees. He has to pay Rs. 1 lakh to his creditor and 50,000 to his wife as dower. He bequeaths his entire property by will in favor of his son. Mahmud dies without discharging his debts. Whether the son will succeed on Wasiyat, discuss. Ans. Under Muslim law, every adult Muslim of sound mind can dispose of his property by will. However, testamentary capacity of Muslim is limited one and he does not possess unlimited power of making disposition by will. There are twofold restrictions on the power of Muslim to dispose his property by will. These are: a. Limitation in respect of person in whose favor the bequest is made. b. Limitation as regard to extent to which a Muslim can dispose of his property. A limitation as regards the person under Sunni law, bequest in favor of an heir even to the extent of 1/3 is not valid unless the other heirs give consent to it expressly or impliedly after the death of testator. Under Shia law, a testator may give a legacy to heir so long as it does not exceed 1/3 of his estate. Such a legacy is valid even without the consent of other heir. But if the legacy exceed 1/3, it is not valid unless other heirs consent to it. So only case in which testamentary disposition is binding upon heirs when bequest does exceed 1/3 of whole estate and when it is not exceeding to 1/3 of estate of testator made to a person who is not an heir. B. Limitation as regards the property. The general rule with regard to the extent of property that may be disposed of by will is that no Muslim can make a bequest of more than 1/3 of his net assets after payment of 1. Funeral expenses and deathbed charges. 2. Expenses of obtaining probate letter of administration or succession certificate etc. 3. wages due for services rendered to testator within 3 months preceding his death by labor, domestic servant etc. 4. Any debt of testator in any form payable to creditor. So after deducting above said expenses or liabilities, whatever will be left can be disposed of to the extent of 1/3 of it by way of will. In view of the above discussion, it is clear that a will in question is not valid because it exceeds the legal third, and also it is made in favor of an heir without consent of other heirs. Therefore, debt of 1 lakh to a creditor in payment of 50,000 rupees is dower to wife of deceased will be made first, and then balance will be divided among heirs of deceased in accordance with provision of succession under Muslim law. Q. 56. A Muslim dies leaving 180,000 rupees worth of assets. He bequeaths 40,000 rupees to a friend and 80,000 rupees for charitable purpose. The heirs refuse to confirm the bequests. Discuss the validity of the bequests both under Sunni and Shia laws. Ans. The testamentary capacity of a Muslim is limited in 2 ways. First restriction is in respect of person in whose favor the bequest is made. Second limitation is in respect of property. Limitation as regard the person. General rule in this regard has been that in case that bequest in favor of an heir is not valid unless the other heir consent to bequest after the death of the testator. In Fukan vs. Mist. Mumtaz Begum, heir 1971 Raj. 149 Rajasthan High Court had held that bequest in favor of an heir even to the extent of 1/3 was not valid under Sunni law unless the other heir consented to it. According to Shia law, testator may give a legacy to an heir so long as it does not exceed 1/3 road of his estate. Such legacy is valid without the consent of other heir. But where whole estate is to be bequeathed to one heir and other heirs are excluded entirely from inheritance, the bequest is void in its entirety. Limitation as regard the property. The general rule with regard to the extent of property that may be disposed of by will is that no Muslim can make a bequest of more than 1/3 of his net asset after payment of funeral charges and debts. Q. 57. What is meant by waqf? Is a waqf valid without designating a mutawali? How can a mutawali be appointed and by whom? Ans. Waqf. The term waqf literally means detention. The meaning of waqf, in legal sense, according to Abu Hanifa, is the detention of a specific thing in the ownership of the waqif or appropriator and the devoting or appropriating of its profits or usufruct in charity on the poor or other good objects. Asaf A. Faizi said that waqf is a pious endowment which is inalienable and therefore supposed to be perpetual, although in actual practice this quality of perpetuity is cut down by several limitations. The term waqf has been defined in Section 2 of the Musalman Waqf Validation Act 1913 in these words: Waqf means the permanent dedication by a person professing the Muslim faith of any property for any purpose recognized by the Muslim law as religious, pious or charitable. Essential elements of a waqf. The essentials of a Muslim waqf are: 1. The motive of a waqf must always be religious. It is generally temporal. 2. The waqf property belongs to God. Therefore, Such dedication must be permanent and irrevocable. 3. Waqif cannot take any benefit of Waqf property. 4. A property which is capable of being endowed in perpetuity can only be the subject matter of Waqf. 5. A Mutawali is appointed to manage the Waqf property for that purpose. He is merely a procurator manager or superintendent. The Waqf property is never vested in him, as such he can never be a trustee. So for the creation of a Waqf, there must be a substantial dedication of usufruct of the property to religious, pious and charitable purpose is understood by Muslim law, and it should be a permanent dedication of property. In Punjab Waqf Board vs Shaka Masih, 1997 Family Law Cases 177, SC, Supreme Court observed. In Section 191 of Mullah's Principles of Mohammedan Law, it is provided that it is essential for the validity of Waqf that the appropriation should not be made to depend on a contingency. Therefore a bequest creating Waqf contingent upon the lifetime of any body is invalid. It observed by Supreme Court in Para number 4 of the judgment, Waqf means permanent dedication by a person professing the Muslim faith of any property for any purpose recognized by Muslim law as religious, pious or charitable. Kinds of Waqf. Under Muslim law, Waqfs have been classified into two categories. 1. Public Waqfs, and 2. Private Waqfs. 1. A public Waqf is one for public, religious or charitable purposes. 2. A private Waqf is one for the settler's own family and descendants and is technically called Waqf al-Awlad. A Waqf in favor of one's own family and descendants is called Waqf al-Awlad. Before Waqf Validating Act, 1913, private Waqf, i.e. Waqf al-Awlad, was held to be void. The Privy Council laid down in Abdul Fatah Muhammad Irshad vs Rusomoidhur Chowdhury that, if the primary object of Waqf is the aggrandizement of family and the gift to charity is illusory whether from the small amount or from its uncertainty and remotedness, the Waqf is invalid and no effect can be given to it. Law after the Waqf Validating Act, 1913. The above said decision of the Privy Council created dissatisfaction among the Muslims of India, who made strong representation to the effect that the law as laid down was a departure from the Muslim law. Accordingly, the Waqf Validating Act of 1913 was passed, under which a Mohammedan can create a Waqf for the benefit of his descendants, provided that the ultimate gift is reserved for charity. Salient features of the Waqf Act of 1913. 1. Under this Act, a Muslim can tie up his property in perpetuity for the support of his family, children and descendants, provided he makes a provision that the ultimate benefit goes to a charitable object of a permanent nature. 2. Such reservation of ultimate benefit may be made either expressly or impliedly. 3. It is no more necessary that there should also be a concurrent gift to charity. 4. It validates, in the case of a Hanafi Muslim, a provision for the payment of the debts of the settler out of the rents and profits of the property dedicated. Before the Act, he could not make a condition that his personal debts should be paid from the property. It is now declared by Section 3 of the Musalman Waqf Validating Act, 1913. That it is lawful for a person professing the Musliman faith to create a waqf which in all other respects is in accordance with the provisions of the Musliman law. For the following among other purposes. A. For the maintenance and support wholly or partially of his family, children or descendants. B. Where the person creating a waqf is a Hanafi Musliman. Also for his own maintenance and support during his lifetime or for the payment of his debts out of the rents and profits of the property dedicated. Provided that the ultimate benefit is in such cases expressly or impliedly reserved for the poor or for any other purpose recognized by the Muslim law as a religious, pious or charitable purpose of a permanent character. Section 4 of the above Act lays down, no such waqf is to be deemed to be invalid merely because the ultimate benefit reserved therein for the poor or other religious, pious or charitable purpose of a permanent nature is postponed until after the extinction of the family, children or descendants of the person creating the waqf. Mutawali, the manager or superintendent of the waqf, is called mutawali. Under the Muslim system, in case of a waqf, all rights of ownership to the property vest in God. The mutawali has no right in the property. He is merely a superintendent or manager. Any person who is of sound mind, has attained the age of majority and is capable of performing the functions to be discharged under a particular waqf, can be appointed as mutawali of the waqf. Waqf without mutawali. If a waqf is created without appointment of mutawali, the waqf according to Shia law is valid and has to be administered by the beneficiaries. However, according to Imam Abu Hanifa, if waqf is created without appointment of mutawali, waqf fails. According to Abu Yusuf, waqf without designating mutawali is valid and the waqif becomes the first mutawali. Mutawali can be appointed by the following, in the given order. 1. By the founder. 2. Failing him, by the executor of the founder. 3. Failing him, by the mutawali on his deathbed. Q. 58 Define mutawali. How and by whom his appointment is made. On what grounds he can be removed from his office. Ans. Mutwali, according to Muslim law, is a manager or superintendent of a waqf property. He is not a trustee and as such the waqf property never vests in him. A mutwali can also not be the owner of a waqf property because once it is dedicated for the purpose of waqf, it belongs to Almighty. In other words, a mutwali is a servant of God to manage the waqf property for the good of his creature. The rights and duties of a mutwali are almost analogous to those of the trustee, yet there is quite difference in between these two. A mutwali has not only to bear the legal responsibilities but also to perform moral and religious duties. Appointment of mutwali. The first mutwali is appointed by the founder of waqf. Waqif. A. Can lay down a scheme for the administration of the trust and for the successor to the office of mutwali and b. May nominate the successor by name or c. Can indicate the class together with their qualifications from whom mutwalis may be appointed. A mutwali's son be appointed by the court also. This happens only when a. A person appointed as mutwali dies, or b. he refuses to act in the trust, or c. when the office of mutwali is vacant and no provision in the deed of waqf is found regarding succession to the office. In brief, a new mutwali can be appointed a. by the founder of the waqf, b. by his executor, or c. by a mutwali on his deathbed as a successor for the time being, or d. by the court. When the mutwali is appointed by the court, the following rules will be kept in consideration while making such appointment. I. The directions of the waqf cannot be disregarded except for the manifest benefits of the endowment. E. A stranger cannot be appointed so long as there is any member of the founder's family in existence and he is qualified to hold the office. E. If there is a contest between the lineal descendant of the founder and one who is not a lineal descendant, the court is not bound to appoint him as mutwali. However, the court has discretion to appoint the other claimant as mutwali in such cases. Powers of mutwali. 1. A mutwali has a power of management and administration of waqf properties. 2. He can apply the income of the waqf property for the purpose of which the waqf was created. 3. He can alienate the waqf property if he has been specifically authorized to do so in the waqf deed. 4. He can sell, mortgage or exchange the waqf property with the prior permission of the court. 5. He can grant a lease of waqf property up to 3 years if it is agricultural land and up to the period of 1 year if it is non-agricultural. If a lease is granted by him for longer period, it can be valid only when a. he was specifically permitted to do so by waqf deed itself, or b. he has obtained prior permission of the court. 6. He can appoint his successor on deathbed, in case the founder and executor of that waqf are dead and there is no scheme of succession after outgoing mutwali. 7. He can appoint deputy mutwali for his help. A mutwali, however, cannot 1. incur a debt. If a person advances a loan to a mutwali for carrying out the purpose of a waqf, he cannot get remedy against the waqf properties. If a decree is at all passed against mutwali on account of any such loan, it will not be binding on waqf properties. 2. Grant lease of waqf property for more than 3 years in case of agricultural land and for more than 1 year in case of non-agricultural land. 3. Alienate the waqf property, unless the waqf deed specially authorizes him to do so or with the prior permission of the court. 4. Sell the waqf property, or any of its part unless specifically authorized by waqf deed and with the prior permission of the court. 5. Take any beneficial interests in waqf properties. 6. Enhance the salary or allowance of officers or servant of waqf unless specifically authorized. Removal of a mutwali. The mutwali may be removed a. by the settlor, if he reserved such power in the waqfnama. b. in other cases, by the court alone, when I. he is found guilty of breach of trust or misfeasance with the waqf property. For example, use of waqf money by the mutwali for purchasing some property in the name of his wife would amount to breach of trust. Bibi Sadiq Fatima vs. Mahmud Hassan, Air 1978 South Carolina 1362. E. Proves unfit to discharge his duties. E. If he claims an adverse possession of the Waqf property, i.e., he claims it to be his own private property. IV. If he fails to keep accounts. V. When he allows the Waqf property to fall into decay by not executing proper repair of the Waqf property. V. If he fails to carry out the instructions of the founder of Waqf. V. If he becomes insolvent. V. Where a mutwali otherwise exceeds his powers in dealing with the property, or X. Where the mutwali suffers from any physical or mental incapacity. Q. 59. Explain fully the concept of Waqf. Discuss the effects of the Musliman Waqf Validation Acts of 1913 and 1930. Ans. The law of Waqf is the most important branch of Muslim law, as it is interwoven with the entire religious life and social economy of Muslims. Waqf in its literal sense means detention or stoppage. According to accepted doctrine of Hanifi school, Waqf is detention of thing in the implied ownership of Almighty God in such a manner that its profits may revert to or be applied to the benefit of His creature. Most comprehensive definition of Waqf is given U.S. 2 of Musliman Waqf Validating Act 1913 as Waqf means permanent dedication by a person possessing Musliman faith of any property for any purpose recognized by Musliman law as religious, pious or charitable. According to Hanifi school, essentials for creating valid Waqf are a. Permanent dedication of any property. Dedication implies intention to create Waqf and b. Declaration to this effect. Therefore, mere declaration to create Waqf by owner is sufficient to complete Waqf. Neither appointment of mutawali nor delivery of possession to him is essential. D. Dedicator, Waqif, should be a person professing Musliman faith and of sound mind and not a minor. A. Dedication should be for the purpose recognized by Musliman law as religious, pious and charitable. In Muhammad, Shah vs. Fashiuddin, Air 1956 South Carolina 713, there must be a substantial dedication of the usufruct of property to religious, pious or charitable aims as understood by Muslim law. Such dedication must be perpetual and subject of Waqf may be any tangible property capable of being used without being consumed. According to Shia law, 4 conditions are required to valid Waqf. I. There must be perpetual dedication. E. It must be unconditional. E. Possession must be given of thing appropriated, unlike Sunni law under which mere declaration is sufficient. IV. Waqif should not reserve any benefit or interest in dedicated property. Before passing of Waqf Validating Act 1913 feet private Waqf or Waqf Alalolad were considered to be void. It was necessary for constituting a valid Waqf under Muslim law that dedication of property must be solely to the worship of God and to charitable purpose, and Waqf in favor of one's own family and descendants were not considered a valid Waqf. In Abdul Fatah Mond, Irshad vs. Rusumoy Dhur Chaudhary, 1894, 22 IA 76 Privy Council laid down that if the primary object of waqf is the aggrandizement of family and the gift to charity is illusory, the waqf is invalid and no effect can be given to it. Q. 60 A. Is the right of preemption a right of repurchase from a buyer, or is it an incident of property? Discuss, bringing out the true nature of the right of preemption. B. What are the formalities that a preemptor must perform in order to succeed in a suit for preemption by him? Ans. A. The right of preemption or shafa is a right to acquire by compulsory purchase in certain cases an immovable property in preference to all other persons. Law of preemption is based on the texts of Muslim law and it is well-founded doctrine in India. Object of the preemption is to prevent the introduction of strangers among co-sharers. Right of preemption is the right which the owner of an immovable property possesses to acquire another immovable property for price for which it has been sold. In Govind Dayal vs. Inayatullah, ILR 7 All. 775 Mahmood J. defined the right of preemption as a right which the owner of certain immovable property possesses such for quiet enjoyment of that property, to obtain in substitution for the buyer proprietary possession of certain other immovable property not his own on such terms as those on which such later immovable property is sold to another person. The main ingredients of this definition are: 1. Preemption is a right which the owner of a certain immovable property possesses to obtain proprietary possession of certain other immovable property, not his own. 2. The right is obtained in substitution for the buyer, who has already purchased that other immovable property. 3. Right of proprietary possession is obtained on the same terms on which that other immovable property is sold to purchasers. 4. Right is given by law for the quiet enjoyment of the property. In Og Behri Singh vs. Gajendra Jaipuri, Air 1954 South Carolina 41 Supreme Court observed, the correct legal position seems to be that law of preemption imposes limitation or disability upon ownership of a property to the extent that it restricts the owner's unfettered right of sale and compels him to sell the property to the co-sharer or neighbor as the case may be. In Indira Bai vs. Nand Kishore, Air 1991 South Carolina 1054, Supreme Court held that right of preemption is a weak right and it can be defeated by estoppel. Even in Muslim law, which is the genesis of this right, it is settled that the right of preemption is lost by estoppel and acquiescence. Ans. B. Right of preemption arises only in case of sale and only when such sale is complete. It does not arise in cases of transfer of immovable property without consideration such as by way of gift. The ground of preemption arises when the sale is complete but it continues, not only up to the date of suit of preemption but till decree is passed. Privy Council in Digambar Singh vs. Ahmad, 1915-37, All, 129, PC, held that these four grounds on which claim for preemption may be based are: A. By statute, i.e. if there is any special act of legislature relating to preemption. B. By custom in the absence of statutory law, the right may be claimed on basis of custom. C. By contract. D. By Muslim law. Under Mohammedan law, the right of preemption may be claimed by following classes of persons. I. Co-sharer in property, Shafi Sharik. E. Participator in the immunities and appendages of the property, Shafi Khalit. E. Neighbor or owner of adjoining a movable property, Shafi Ja. Class 1 is entitled to preference over classes 2 and 3 and class 2 over class 3. In order to be entitled to the right of preemption, a preemptor or authorized agent should make the following demands, talabs. I. He should immediately on receiving information of the sale declare his intention to assert his right. This is called the talabim wa sibat, the first demand. 2. He should, with the least delay possible, affirm his claim for preemption in the presence of at least 2 witnesses after sufficiently specifying the property and referring to the first demand. Either in the presence of the vendor or the vendee or on the premises which are the subject of the sale. This is called talabi ishhad, or talabi takre, the second demand. These demands are conditions precedent to the exercise of the right. Q. 61 Discuss the right of maintenance of a Muslim wife. Ans. A wife has an absolute right to maintenance. It is incumbent upon the husband to maintain his wife, says the Fatwa I Qazi Khan, whether she be Muslima or non-Muslima, poor or rich, young or old. The wife who is regularly married and who has attained an age at which she can render to the husband his conjugal rights, is entitled, while the marriage subsists, to receive from him maintenance, according to her health and position in life and his means, provided that she places or offers to place herself in his power so as to allow free access to herself at all lawful times and obeys all his lawful commands. Her right remains unprejudiced even if she has property or income of her own. The husband is bound to maintain her if she fulfills the following conditions. I. She has attained puberty, i.e., the age at which she can render to the husband his conjugal rights, and e. She places or offers to place herself in his power so as to allow free access to herself at all lawful times and obeys all his lawful commands. Even if the husband is minor, incapable of consummating the marriage, and the wife is adult, she is entitled to maintenance. If the minor husband has no source of income, the father of the minor is liable for her maintenance, though he has a right to recover from his son. A wife, whose marriage is not consummated, may abandon the matrimonial home or may refuse sexual intercourse to the husband if he has not paid prompt dower to her. In such circumstances, she is entitled to claim maintenance from her husband. Ahmad Giri vs. MST. Begha, AIR 1955 J in K1. She is not entitled to maintenance under following circumstances. I. If she abandons the conjugal domicile without any valid cause. E. If she refuses access to her husband. E. If she is disobedient to his reasonable commands. IV. If she is minor, on which account marriage cannot be consummated. Order for maintenance. If the husband neglects or refuses to maintain his wife without any lawful cause, the wife may sue him for maintenance. She is not entitled to a decree for past maintenances, unless the claim is based on specific agreement. She may also take shelter of Section 125 of the Criminal Procedure Code. 10,973, under which the court may allow a monthly allowance for her maintenance not exceeding 500 rupees, or under the Dissolution of Muslim Marriage Act, 1939, Section 2(e). A wife is entitled to dissolution if the husband has failed or neglected to provide maintenance for a period of 2 years. Duration of rights of maintenance. A Muslim wife is entitled to get maintenance from her husband on divorce till the period of iddat. Such right is terminated on husband's death. In such cases she becomes entitled for inheritance in the property of her deceased husband. Although under Muslim personal law a husband is not bound to maintain his wife after the expiry of the iddat of the divorced wife, but U.S. 125 crossing PC. He is bound to maintain her even beyond the period of iddat, provided she remains unmarried. In Muhammad Ahmad Khan vs. Shah Bano in Othras. Air 1985 South Carolina 945, Supreme Court observed that the religion preferred by a spouse or spouses has no place in the scheme of Section 125 crossing PC, which is a measure of social justice founded on an individual's obligation to the society to prevent vagrancy and destitution. If there is any conflict between personal law and Section 125 crossing PC, then it is clear from language of the section that it overrules the personal law. It was held that a Muslim woman who cannot maintain herself is entitled to maintenance from her husband till the time she remarried. Judges rejected the plea that maintenance to a divorced Muslim wife is payable only till iddat period under Muslim personal law. Judgment of Supreme Court in Shah Bano's case created a controversy. Many Muslim leaders opposed this verdict as being opposed to the Shariat. They contended that maintenance by a former husband to a divorced wife after the period of iddat is against Islamic religion. As a consequence of this opposition, the Parliament enacted Muslim Women Protection of Rights on Divorce Act, 1986. The provisions of this act relating to maintenance of a divorced Muslim woman may be summarized as follows. 1. The divorced woman is entitled to a reasonable and fair provision and maintenance during the iddat period from her former husband, Section 3(1)(a). 2. Where she herself maintains the children born to her before or after her divorce. A reasonable and fair provision and maintenance to be made and paid by her former husband for a period of 2 years from the respective dates of birth of such children. Section 3(1)(b). 3. Where a divorced woman has not remarried and is not able to maintain herself after the iddat period, she is entitled to get maintenance from her such relatives who would inherit her properties upon her death. Section 4(1).